Petitioner, I provide respondent lordship.
Yes.
5 and 6. This connected matter.
What is to be done?
I'm seeking time, lordship.
Yes. So tell us how much time you need.
After 2 weeks, lordship. 2 or 3 weeks.
Yes.
Also.
Objections, madam.
This is a 5 and 6 also. The request of the petitioner. List of references. Yes.
Deeply obliged.
Much less, lordship.
May it please your lordship. Lordship, I beg to mention item number 11.
Yes.
This matter may be taken up after a week, my lord.
No settlement.
No, settlement could not be.
Was it sent to this thing mediation? Sent for mediation?
It was not sent. Not
Sent
sent.
for mediation.
No,
Any likelihood the matter will be
no, your
settled?
lordship.
No, well, let the mediators try. Anyway, we'll see. Yes, right now, what is your prayer?
To adjourn the matter by a week, my lord.
I have no objection, your lordship.
It's a maintenance matter.
Yes, your
Maintenance.
lordship.
You are getting maintenance.
Your lordship?
You are getting your maintenance. You are receiving.
No, your lordship.
You are not paying. What is the order under challenge here?
Order ex parte identity maintenance order was passed
Why
against me.
Why you are not paying? You should pay.
And seek instructions, my lord.
Yes. Just say petitioner pays for adjournment of the matter by a week. London comes about the respondent has no objection. There are alert list of the yes.
I'll do.
Oblige, your lordship.
Yes.
I beg to pray for 2 weeks time, my lord. Item number 12.
No objection, lordship.
2 weeks at the request of the petitioner.
Obliged.
Much obliged, lordship.
May please, Lordship. Lordship, I beg to mention item 14.
13?
14, Lordship.
Yes.
Lordship, this matter can be taken up next week, Lordship.
Why next week?
Lordship, lots of matters are being listed today, Lordship, which the senior counsel, Mr. Khalkhan's.
This is a matter.
Lordship, this is a wildlife matter, Lordship, whereby the this vehicle was confiscated by the wildlife officer, but then
Transporting exotic.
exactly, Lordship, with the regarding to Amendment Act, and
And you say that this once it is
it becomes a government property, Lordship.
no proclamation is needed.
Lordship, a similar prayer for item
What is
15
also?
now.
2 weeks with the request of the request made on the way of the petitioner. Okay. Yes.
Lordship, similar prayer for item 15 now.
Which also no one is appearing.
Lordship, as per service was
15 is this on the question of the power of the district council.
yes, Lordship.
But then that is matter is pending before FX court, isn't it?
Lordship, different. Yes, Lordship, the appeal is then.
There is a matter earlier.
Lordship, the division bench of this court has.
This went on challenge before the apex court.
Lordship.
Now the apex court did not interfere, okay, with the order, but then kept the matter open. Then subsequently it was again decided with the High Court in affirmative, saying that there is the power. The challenge was made, and probably it was in 2015.
Lordship.
Any idea, Dr. Mojiga, about the power of the district council to grant anti-septic bill? There was a matter pending before the apex court in probably 2015-16, and then
that because the matter went to Supreme Court, that we will know.
yes,
But after that, whether
this
this is
court
still
also
pending or disposed of.
I think it has not been decided till.
Doesn't AG in a better position?
Lordship, because as per my research,
But then
before
as of
Supreme Court-
now, if at all, if there is no order by the Supreme Court, then the power is there. Because that is what this High Court has held. The Supreme Court has not given a stay on that.
Lordship. But then also we are on that issue where the
High Court said, my lord, that district council doesn't have power. Justice sense order.
That is a past one.
division bench of
There were.
Justice Maheshwari and had gone to.
Oh, then that order has been stayed then by the Apex Court. That order has been stayed with them.
Yes, Lordship.
If the High Court has held that, there no power, then probably there is a stay.
Lordship, division bench.
Anyway, please verify.
I will.
verify.
I'll also try to verify.
I'll oblige.
This also 2 weeks at the request made on way of the petitioner. 14-15 same. Yes.
May I please, your lordship? I beg to mention item number 3. I'm praying for a week time, your lordship.
Yes.
So, I'm praying for 1 week time. This matter.
You are appearing for?
I'm appearing for Sir Asu, Senior Counsel. Sir Asu, for the petitioner.
Your lordship. No objection. After a week?
Yes, sir. Yes, sir.
Here after a week or
Yes, sir.
1 week? Just make one the petitioner. Okay. Yes.
Lordship, I'm bringing on accommodation in item 9. Lordship.
Item 9.
9. Lordship.
Which is the other side?
I'm sharing
on
this.
behalf of
The state.
state respondent to lodge.
Yes, madam. Any?
Bring for accommodation for a week. Lordship.
A week seems all right, your lordship.
1 week at the request of the petitioner. Yes.
Highly obliged.
Obliged to lodge.
May it please, Your Lordship. Lordship, I beg to mention item number 2, Your Lordship.
Item 2.
Lordship. Lordship, Leonard Senior Counsel Mother is seriously ill, Your Lordship.
Lordship, to me it's a fixed matter, but since
Personal. His mother is seriously ill.
Seriously ill, Your Lordship.
Yes. Problem.
Your Lordship, so far as concerned with settlement and all, there's no such approach.
That is only for the purpose of buying time, nothing else.
Yes.
As it seems, it is apparent. We'll see. We'll take care of all those things. The matter is to but if you see, like, time is short on that ground, then to refuse it would not be proper. Yes.
2 weeks, Lordship.
Yes. Mr. Swans, Learned Counsel. Praise for adjournment matter on the ground of personal difficulty of the Learned Senior Counsel. Appearing for the petitioner. The Learned Counsel of the respondents have no objection. There are list of activities. Yes. Obliged.
Highly obliged, Lordship.
Item number 1.
Yes, Mr. Shen, what is your instruction?
So Lordship's query was whether an award had been published individually for all these claimants. One set of claimants are those who have already received the compensation, and another group which has not yet received the compensation. We could not get all the information, but in 2021, the draft award was sought to be published.
What this court wanted to know, whether the name of all the petitioners appears in the list of beneficiaries.
Yes, I have inquired. There is, and also there is a group. So originally the writ petition had about 90 petitioners. A group has already been paid, and they have been struck off by this honorable court. As far as they are concerned, award statements have been made. There's another group of people which have not received the amount of compensation. Their name also features.
Sit down, Dr. Modi. Why you are studying? Well, there is.
So awards have been prepared individually for all these petitioners.
So
Yes.
all of the petitioners' name
Yes.
appear in the list.
Yes.
Yes, Mr. Sangresho. Tell us what your case is.
Lord, my challenge remains the same. I will pursue my Lord.
You are challenging the acquisition procedure.
Acquisition process.
Yes.
Especially section 19 in other letters issued by the district council. My humble submission before entering into the war issue, preparation of the award, even if the collector has done already, will never sanctify the illegality committed by the collector prior to preparation of award. So my challenge remains the
According to
same.
you, what are the provisions which were not followed?
Yes.
Which basically the collector should have followed.
Well, main thing is matter of the section 15, right to be heard, opposite of being heard. That is the main thing, man.
So you none of you have been heard.
Yes. We make a specific amendment, and the respondent collector did not deny, and the record also never demonstrate that they have appeared. The report, the collector has been heard. The petitioners, he prepared the report on the basis of the objection raised by the petitioner, or collector has prepared recommendation and sent to the government upon which government has taken decision for section 19. Now, my lord, if I go to the annexures, averment, because averments, it is perquisites are there, it is not denied. May I go to the provision? Section, my lord. Section 15, my lord.
Now, is there a plea that section 12 notice not served? What is section 12 notice?
Section 12, my lord, after preliminary notification under section 11, they have to serve a notice to the individuals under section 12 to enter upon my land to conduct survey.
That notice was not served. This is also one of the.
One of the.
Probably this is a submission you are.
Yes, earlier also, because I did not, my lord, deem it fit to repeat again, because substantially I also argued on those points earlier also. But for recollection of a memory, my lord, section violation of section 12 is also I pleaded, I argued also. And primarily, my lord, main is section 15. In section 15, a substantial provision. I will place the authorities. What is the consequences of non-adherence to section 15? And I'll place it. And if, my lord, section 15 is not adhered to, what is the, my lord, the status or legality of the declaration under section 19? My humble submission is that section 19 declaration do not stand if section 15 is not complied. My lord, I invite lordship to section 12. New Act 2013. Earlier it was section 5. I do not need to go for section 11 for preliminary notification below. But the next step after section 11 is this.
Section 12.
Section 12.
Now, you say no notice was served. No notice was served.
My lord.
Yes.
My lord. May I come to the proviso?
What is the consequence of non-service of notice under section 12?
My lord.
The consequence of non-service of notice under section 12.
My lord.
What is the consequence?
But the consequences, it affects my right. But it affects my right. And ultimately, the further steps taken by the collector.
Will it vitiate the entire proceeding?
But it is part of the part, my lord. Part of the.
What is your submission? What stand you are taking? That is what this.
It will vitiate. It will be the ground for vitiating the process. Because the LA Act has provided inbuilt procedure. My lord. That procedural law, I will cite authority, required to be strictly adhered to by the authorities.
That is mostly on section 15.
Yes, and because you result to deprivation of the right to property.
So you can say that is a cumulative effect of non-adherence of section 12.
Yes, ma'am. So section 12 require for individual notice. That is not done. Now may I come to section 15?
Yes.
And section 15 is very important. Hearing of objections. Any person interested in any land which has been notified under subsection 1 of section 11 as being required for likely to be required for public purpose may within 60 days from the date of the publication of the preliminary notification object to the area sunset matter. Every objection under sunset shall be made to the collector in writing, and the collector shall give the objector an opportunity of being heard in person or by any person authorized by him in this behalf, or by an advocate, and shall, after hearing all the objections and after making such further inquiry, if any, as he thinks necessary, either make a report in respect of the land which has been notified in the such and such, or make a different reports in respect of different parcels of such land to the appropriate government, containing his recommendation on the objections, together with the record of the proceedings held by him, along with a separate report giving therein the appropriate cost of land acquisition, particularly as to the number of affected families likely to be resettled for the decision of the government. The decision of the appropriate government on the objections made under such and such shall be final. Now, if I gather from here, my lord, after the landowner, interested person, raise an objection, collector has to hear
There is objection.
Yeah, objections, applications.
On behalf of all the petitions.
Yes.
Where is it that objection?
Objections, my lord, it is there in an extra is there.
This annexure, just give us the page number.
Page number.
There is no dispute that this
Objection, yes, yes. This is denied that they did not deny that they
Yes, Mr. Shen, you are not denying that.
The
part.
affidavit is not
Objection was filed under section 15. There is no denial to that.
He has given a reply
No,
that
if you also
they are participating, so
See, the contention of the petitioner is there. They objected to the acquisition proceedings under section 15. Now, the law contemplates once objection is filed, we will have to decide it by giving them opportunity. Now, that is where the stand is. The question by the court is that their contention that they had filed objection, whether you dispute it or no, you are not disputing.
There is some issue with that. The objection was not signed by all the 90
Okay, so it
petitioners.
means there is not a flat admission.
Yes.
Okay, we'll come to you then. We'll come to you. You just tell us. Yes, where is the objection?
my lord, that page number 187. Page number 187.
That is an objection on behalf of all the.
My lord, here the 60 signatories are there, and subsequent objections are also there. My lord, can you see?
Then what are the pages? Just give us.
Page number
187. Then
87. 187, my lord, and other objection also there. Let us see. Page 200 also. Annexures are there. 17, 18.
now, how many writ petitions are surviving now?
Now surviving 46 only, madam.
And where are their objection? In which page?
What?
The objection filed by this on behalf of this.
Yes.
Where do we find it?
Lordship, can you see page number 188?
188.
Yeah, 188.
Yes, and then
That their names are also.
Not page 187.
Yes, page 187 is the my lord, the beginning of the objections,
No.
and the names are reflected in 188. Name of the
Okay,
petitioners
right.
also.
And then
Well,
that we'll find the name of all the petitioners.
yes, my lord, I could trace out here 28 petitioners. I could easily find out here also. Yes, their names are there.
Okay.
Those who are remaining the petitioner today.
28.
Some of them withdrawn already. Their names struck out. So we are.
Anyway, if at all it is sought to be disputed, then we will have to.
We will, my lord. We will
Anyway.
Pinpoint those particular.
For the timing,
petitions.
proceed. Okay.
Right.
Now,
And the averment with regard to that is, my lord, para 20 of the writ petition.
section 15(3).
Yes, objection we find. Para 20 of the
That
writ
has not
petition.
been done.
Yes, and that is that.
Para?
Para 20 of the writ petition, and the respondent, my lord.
It's okay, Mr. Shangreshi. If you say that has not been done, you don't have to refer to this. If they have not specifically anything, we'll just see.
Yes, they are not saying that we did not file an objection.
Let the state
Impliedly,
starts their
Yes.
start their case and then.
Right.
Yes.
But so that is there, and my lord, the section 11, section 15, my lord, that is a mandatory requirement.
Yes.
Now, the objection by this, my lord, section, collector has no power to reject my objection.
No
But
power
the
to reject
duty-
your objection.
Yes, collector has the power to hear me. And he has the power to, after making inquiry, he has the power to prepare a report on the basis of my objection. And he has the power to prepare a recommendation. Along with the recommendation records, he would send to the government. Government, before issuing section 19, has to apply its mind independently objectively consider and apply its mind whether the land acquisition process would be viable for purpose or not. Because ultimately, my lord,
Section 19, decision will be taken on the basis of the recommendation of the government.
yes, but because the government is not the one who is interacting with the landowners, affected party. It is the collector down the line. He is interacting with the active person, interested person. Therefore, he is the right person to bring the grievances of the objectors, also called interested parties. Now, government has to examine, including the cost clearly mentioned. When the collector prepare report and recommendation, he has to highlight the costs involved therein also. Now, government will consider public interest as well as the cost involved. If the cost, for example, my lord, cost is, my lord, 1 lakh. Government's budget is 1 lakh. Land allocation for the compensation is 1 lakh. And DC reports more or less the same thing. There is no financial difficulties for the government. But when the collector give a report saying that all these landowner demand this amount of money, it crossed 1 lakh, it reached to 2-3 lakhs, for example.
Section 15, there is an objection with regard to the acquisition proceeding or with regard to the rate.
But they can raise, my lord, all the issues, measure areas, my lord.
For that, see, there are provisions to take care of those things at a subsequent stage. So just because this is the probably when you clarify, it's subject to what you say. You see, just because you see, like the rate offered was not according to your expectation.
Exactly.
I don't think that will vitiate the entire.
Exactly, my lord. Because another forum is available.
Yes.
For the affected party, for the interested party.
You can skip that. At least basically raise before those points which would vitiate the process. Because your challenge is to the
including the area. Now here area is involved.
See, two things. Can you take both the stands together?
Yes. Right.
Insufficiency of rate or any dispute regarding the area, and at the same time you challenge the proceeding. Now, if you challenge the proceeding, you confine to that. You do not have to come to.
But cost, leaving aside the cost.
But then, if you come to other point, then rate court may not be able to.
I will not canvass my lord to decide which one is ROW, which one is not ROW. I'm not canvassing that one. But the basic grievance of the petitioner under section 15 would be, had the collector give us opportunity, they would have definitely raised the area of the land that touch upon the ROW.
But then that option you have to know.
No. My lord, the right to be heard includes, maybe a citizen may have a grievance with the area, grievance with the grounds I mentioned, my lord, area, justification of public purpose, finding out the special social impact assessment. These are the rights of the citizen to address before the collector. Collector has to hear us. Merely, my lord, I have opportunity, forum, to raise the amount, to raise the measurement under section 18, and now under section 64. That doesn't mean that collector cannot say, I cannot hear. I do not need to hear. I'll please the authorities. Collector has to hear. It is his statutory duties. And Apex Court said it is a substantial provision of law.
And your stand is that collector has not heard you.
Collector has not. And once collector is not heard.
That is also the admitted position.
Yes. And now the consequence, madam, Lordship will examine. If the collector do not hear, then what is the consequence? The consequences of the preparation of report or recommendation, whatever record sent by him to the government, is invalid. And once the report, recommendation, or record prepared by the collector is invalid, there is no basis for the government to take a decision to issue Section 19 declaration. So Section 19 declaration is vitiated. But if I could convince my lord,
once there is a non-compliance of Section 15(3),
yes,
19 would be standard.
19 will go. Yes. And what happened in that event, the Apex Court set aside Section 19, and the decision is left to the government. If you want to proceed further, then you adhere to right to be heard under Section 15. If you don't want, then the acquisition process will lapse. Those consequences will come. Consequences will come. I have no power to stop the government.
Say, supposing if we accept your submission and quash the entire proceeding at this stage,
yes,
then what happens to all the persons, those who have received compensation, and they were those who were earlier part of this?
Right. But there is a decision outside the authorities. This honorable court do not need to cost the entire proceedings. If the illegality is so glaring, Lordship discretionary power is still vested in your Lordship's hand to cost entire thing. But if the Lordship comes to a finding that larger chunk of the people have no grievance, and few of them are here, and they make out the case, in that case, my Lord, on Apex Court say that this Honorable Court can quash the proceedings in person.
In relation to them.
In relation to those people, and with regard to that, government can take a fresh decision. If they want to proceed, they can resort to due process of law. If they don't want, they may not proceed. So I'll place decision. Because, my Lord, there are more than thousands landowners are there. The kilometers of land they have taken away, and I'm nobody to canvass their rights. So if 46 of them, my Lord, persuade my Lord.
Now, say supposing
yes,
we interfere, we quash the proceeding in respect of certain individuals.
Yes.
The government will have the liberty to initiate again.
Yes.
Fresh proceeding, isn't it? Yes. Now, what purpose it serves there?
Well,
because your objection is to the acquisition proceeding.
Yes.
Then if they again initiate fresh proceeding, then again section 15 will have to be adhered to.
Yes. Yes. Right.
And then can this process be go on like this? That you see, like you challenge against the acquisition proceedings, again it is interfered. Then again the government will have the fresh authority to initiate fresh proceedings. Can there be legal solution like this?
My Lord, suppose if Lordship convenes contention, set aside with the Section 19 declaration, and my Lord, government has to adhere Section 15.
Yes.
Once collector adheres Section 15, petitioner would place their objection, including the areas, ROW, whatever grievances they have. Collector has to hear them, prepare a fresh report, recommendation. This is the grievance of the landowner. Then you take a fresh decision. If the government apply, then okay. Earlier, my Lord.
No. The court query is with regard to
yes
the situation where court quashes.
But
say supposing you are successful in your petition.
Yes.
Now government will have the liberty again to initiate another proceeding, isn't it? Now in such a event, if such an event, the government will have to follow the provisions of Section 15.
Yes. Yes.
Isn't it?
Right.
So does it serve any purpose? You see, if the government has the authority to do it again, and it is only for the purpose of, you see, like correcting the irregularities, then what purpose it serves?
But that is what the law. But I'll place a decision. They have collector has to hear.
It brings any consequence or.
But collector has to hear it, and after collector hear, he will prepare a fresh report and recommendation. In that recommendation and report, grievances of the petitioner, that the losing of the huge areas of land is placed before the government. Government may take a decision. It may say, okay, we will ignore it with regard to the ROW or the area of the land, whatever. Let them go to the reference court. They can take a decision. Or government may say, oh, earlier it was not there. Now the cost would be escalated if we include those areas also. Government may apply its own fresh mind and take a decision. My Lord, merely, my Lord, the destination would be the same thing.
Yes, Mr. Shen, without going into any hassle, if you have the liberty to initiate a fresh proceedings, that will only amount to this thing. Oh, but then you see, like
it's the same exercise.
So but it will only thing is that it will afford them another opportunity.
Okay.
So is there any difficulty in doing that?
I have a different take on this one.
No. We are not saying you to do it.
We can, if your
Lordship
Lordship is
asking
satisfied.
for.
If your Lordships find that hearing was not, an opportunity of hearing was not given to them, for the hearing contemplated in Section 15, you would have to abide by that order. But I would satisfy your Lordships that the hearing under Section 15 would not be required. I'll make an endeavor to satisfy them.
Yes. Well, therefore, precisely my submission is, my Lord, if Section 15 is not complied with, collector has to, my Lord, to be directed by my Lord to adhere to. And that is the substantive provision of law provided.
What is the decision you are relying upon?
But I'll place the decision.
Is there any other point to challenge except for Section 15?
Well, Section 15 and other impugned orders are there, and especially the District Council, where they issued a letter that the land that falls within the so-called the 35 feet do not call for payment of compensation.
ROW.
It touched the ROW.
See, that is, I think once your main thing is that a challenge to the
But if section
ROW, if there is, say, supposing if your contention with regard to ROW is accepted, that also will not vitiate the procedure.
But that ROW issue we can take up before the collector.
Yes.
Under section 15 also. 15 also.
If you are not successful here.
Yes.
Yes, what is the decision you are relying upon?
Now, decision may I please? Because my other side may argue that earlier they have calculated, prepare the award.
You are referring decision on the anticipation of what?
But I'll satisfy the connected issue that may arise. But first, I may confine them to my lord. Latest 2023 volume 6.
You give us first one that concerning that section 90, section 50. That is more appropriate here. You see, like that would be your main point.
Now, 2023 volume 6 SSC, page number 512. Page would be relevant para would be 24.
512.
Para, yes, para 24. volume 6 SSC 512 para 24. I may not need to narrate the previous
para 24
paragraph by the way they refer to para 5A, section 5A. I may come straight with the para 24.
Yes.
As a careful scanning of all the provisions cited by both sides would thus reveal that all those decisions hold that land acquisition proceedings under the LA Act begin with the publication of a notification under subsection 1 of section 4. A declaration under section 6.
That is with regard to the old Act.
This matter relates to all Act. A declaration under section 6 of the LA Act is one of the steps under the LA Act, which ultimately culminates into conclusion of the proceedings by making an award and taking possession of the acquired land. A declaration under section 5 cannot be made without holding an inquiry unless urgency clause under section 17 is applied. It's very clear.
Here it is not this invocation of urgency clause.
They did not invoke. So the apex court said that you, my lord, without invoking section 17, in that case, inquiry under section 5A is a must. And if you don't adhere to, your section 6 declaration
section 5.1 is in parametry of section.
Yes, exactly. So section 6 declaration cannot. This is one decision. Another decision, my lord, I may come to supply.
Same point.
Well,
same point.
Yes, substantive provision of the. My place decision. It's a 2024 decision.
It's not reported.
Well, this volume not yet published. SEC yet to publish this decision.
Yes. This will be para?
But I may start from para 27 to 31. This is a Kolkata Municipal Corporation versus Bimal Kumar Shah. Para 27 to 31.
Yes.
Madam, para 27 may I start?
Yes.
Well, what then are these sub-rights or strands of this Swadesi constitutional fabric constituting the right to property? 7 such sub-rights can be identified, albeit non-exhaustive. These are the duty of the state to inform the person that it intends to acquire his property, the right to notice. The concern, number 2, the duty of the state to hear objection to the acquisition, right to be heard. The duty of the state to inform the person of its decision to acquire, right to a reasonable decision under Section 16. The duty of the state to demonstrate that the acquisition is for public purpose, the duty to acquire only for public purpose, the duty of the state to restitute and rehabilitate the right of the restitution of fair compensation, the duty of the state to conduct the process of acquisition efficiently and within prescribed timelines of the proceeding, the duty of an efficient expeditious process, and final conclusion of the proceedings. Now, these 7 rights are fundamental components of a law that is in tune with Article 300A, and the absence of one of these or some of them would render the law susceptible to challenge. The judgment of this court in such declared that the law envisaged under such must be in line with the overarching principles of rule of law and must be just, fair, and reasonable. It is, of course, precedentially sound to describe some of these sub-rights as procedural, a nomenclature that often tends to undermine the inherent worth of these safeguards. These 7 sub-rights may be procedures, but they do constitute the real content of the right to property under such. Non-compliance of this will amount to violation of the right, being without the authority of law. May I continue further, my lord? May come to save lordship time, may come to para 31.1. May I skip that one? May I straight come to para 30.2? 30.2. Yes. That relates to section 5. Yeah. Following the right to a meaningful and effective prior notice of acquisition is the right of the property bearer to communicate his objections and concerns to the authority acquiring the property. This right to be heard against the proposed acquisition must be meaningful and not a sham. Section 5A of the Land Acquisition Act, Section such of the Requisition such, Section 15 of the Fair Compensation Act, and Section 3C of the National Highway Act are some of the statutory embodiment of this right. Well, may I go travel further? Well, para point 3, 30.3, right to a reasoned decision. Well, yes. Well, that the authorities have heard and considered the objection is evidence only through a reasoned order. It is incumbent upon the authority to take an informed decision and communicate the same to the objector. Sections and such, well, in Section 19 of the Fair Compensation, these are the statutory incorporation. Well, yes. Now may I go to the page, my lord, point 30.7, running page should be 26. Yes. Well, right of conclusion. Upon conclusion of process of acquisition and payment of compensation, the state takes possession of the property in normal circumstances. The culmination of an acquisition process is not in the payment of compensation, but also in taking over the actual physical possession of the land. If possession of the land is not taken, acquisition is not complete. And here is the concern. They did not take over, therefore the issue of eviction notice here in the lordship has taken. With the taking of the actual possession, after the normal procedure of acquisition, the private holding is divested and the right, title, and interest in the property along with possession is vested in the state. Without final vesting, the state's or its beneficiary's right, title, and interest in the property is inconclusive and causes a lot of difficulties. The obligation to conclude and complete the process of acquisition is a part of the articles and such. Now, 31, just come to 31, para 31. The 7 principles which we have discussed are integrated to the authority of law, enabling compulsory acquisition of private property. Union and state statutes have adopted these principles and incorporated them in different forms in the statutes provisioning compulsory acquisition of immovable property. The importance of these principles, independent of the statutory prescription, have been recognized by our constitutional courts, and they have become part of our administrative law jurisprudence. Now, it is important, my lord, the Honorable Court says that it is the basic principle of fairness, is section 5A, and the position also, my lord, here I will sort of discuss about the position. Mere payment of compensation will not amount to conclusion of the acquisition. You have to take over in accordance with law. And admittedly, in my case,
we are not on that issue, right? But if you are successful in showing,
yes,
even if acquisition is completed, will there be a bar for this court to interfere?
Exactly.
If 15.3 you saw that there is a non-compliance of it.
Right. It is not part of my lord to interfere, to exercise your lordship.
If you
Another
go by
decision, may I please, is my lord 2017, volume 11, ACC.
So on what question that was?
My lord, this also, my lord, the power of the collector under section 5A and the government power under section 6.
Yes.
This is quite relevant.
2017.
2017, volume 11, ACC, page number 601. And relevant para, my lord, may I refer, para 96 to 98, lordship may take note of it, 96 to 98, comma, my lord, para 143
Yes.
and 152 and 53. Is a lengthy judgment.
Yes.
But para 96. But.
At what page? Para 96?
Para 96. 96 to 98.
Yes.
Well, now in Sri Mantir Situ Ramji versus in City of Delhi, a constitution bench of this court has held that it is the mandatory duty cast upon the collector to follow the provision of section 5. Now, the learned single judge allowed the writ petition on the basis that the appellant had no opportunity of being heard by the collector under section 5A. The duty to afford such an opportunity is mandatory. A decision by the government on the objection when the collector afforded no opportunity of being heard to the objector would not be proper. The power to hear the objection under section 5A is that of the collector and not of the appropriate government. It is no doubt true that the recommendation of the LA collector is not binding on the government. The government may choose either to accept the recommendation or to reject it. But the requirement of the section is that when a person's property is proposed to be acquired, he must be given an opportunity to show cause against it. Merely because the government may not choose to accept the recommendation of the land acquisition collector, even when he makes one.
So I don't think there are any different view other than what.
But
I don't think that proposition of law will not be disputed.
Yes. Therefore, my lord, I am placing the authorities that once section 5A is not adhered to, subsequent action is absolutely invalid. Now, the government decision under section 6, government decision as section by lord, the section 15 subsection 1 under the new act is also resultantly invalid, illegal. Because the Apex Court says that if the collector do not hear, whatever decision taken by the government will not be considered as valid.
Because this is a prerequisite. See,
Prerequisite.
without recommendation of the collector,
it is a
government
prerequisite.
cannot take a decision.
Yes. It is a prerequisite.
That is what appears to be.
Yeah, exactly, madam.
Anyway,
Madam, if I travel down, my lord, the
no,
next.
okay. That is all. You see, if there is any purpose for reading, definitely.
But these are the one. And may I come to my lord 86? Sorry, 96, 98, para 98.
Yes.
From perusal of the proceeding before the collector, which are made available to this court, it becomes clear that the same have been rejected without assigning any reasons or application of mine. Thus, the report of the collector is not a valid report in the eye of law. The state government has mechanically accepted the same without application of mine independently before issuing the notification under section 6 of the LA Act, declaring that the land are required for establishment of such. This is one.
It is that the recommendation of the collector also is not enough. The state will have to apply its mind.
Right.
Cannot mechanically go by the view expressed by the collector.
Yes. Exactly. Well, and this is exactly the point I'm.
Yeah, we have not gone to that extent. If you say that there is no recommendation here, the
My lord, whether he has made a report and recommendation, we don't know. Even if assuming that he made a report and recommendation, in view of the fact that the parties are not heard, recommendations and the reports are invalid. And the government taking decision on the basis of the reports and recommendation is also consequentially invalid.
Yes.
Invalid. May I come to my lord,
143.
143?
Yes.
Jumbo elaborate. And my lord, the apex court quoted the previous judgment, and may I come to that. 143.
Yes.
And my lord, the next page there they quoted my apex court early decision, paragraph 84. The next page.
Yes.
Yeah, 84 may.
The bottom.
What needs to be emphasized is that hearing required to be given under Section 5A to a person who is sought to be deprived of his land and who has filed objection to Section 5A must be effective and not an empty formality. It's important now. Well, empty formality. Collector who is enjoined with the task of hearing the objector has the freedom of making further inquiry as he may think necessary. In either eventually he has to make a report in respect of the land notified under sections and such, or make a different reports in respect of different parcels of such land to the appropriate government containing his recommendation on the objection and submit the same to the appropriate government along with the record of proceedings held by him for the latest decision. The appropriate government is obliged to consider the report, if any, made under subsection 5A and then record its satisfaction that the particular land is needed for a public purpose. This exercise culminates into making a declaration that the land is needed for a public purpose, and the declaration is to be signed by a secretary to the government or some other officer duly authorized to certify its order. The formation of opinion on the issue of need of land for a public purpose and suitability thereof is sine qua non for issue of declaration under such and such. Any violation of the substantive right of the landowners and all other interested persons to file objection or denial of opportunity of being a personal hearing to the objector vitiates the recommendation made by the collector and the decision taken by the appropriate government on such recommendation. The recommendation made by the collector without duly considering the objection filed under such and submission made at the hearing given under such or failure of the appropriate government to take objective decision on such objection in the light of the recommendation made by the collector will denote the decision of the appropriate government of statutory finality. To put indifferently, the satisfaction recorded by the appropriate government that particular land is needed for public purpose and declaration under such will be devoid of legal sanctity if statutorily engrafted procedural safeguards are not adhered to by the authorities concerned, or there is a violation of the principle of natural justice. The cases before us are illustrative of flagrant violation of the mandate of such. Well, it is settled position of law. Settled position of law. But my lord, the moment it is not adhered to, my lord, merely my lord, the interested party would have a forum, our reference forum, cannot be the ground to reject the or to endorse the illegality of the collector action. So, we'll come back after.
Item number 1.
Where is Mr. Sandesh?
Not seen him around. I've not seen him around. I've not seen him. Maybe taken up at the end of the day.
If we are into another matter, then it will not. Should it be here? Why he is not here? Let's finish his part or yes, madam. Where is Mr. Sandesh? The entire issue is confined to non-compliance of provision of section 15.
15, my lord. 15.
Mr. Sandesh,
Sorry.
the court is waiting for you.
I'm sorry. My lord, with lordship permission, I'm allowed to cite for the decision, my lord. My lord, 2013-4 ECC.
Yes.
2013 volume 4 ACC, page number 210.
Yes.
And well, relevant para may start from page para 18 to well, the 32. I'll select a relevant one while read out the lordship permission. First para my lord 18.
Yes.
Well, we also find merit in the argument of the learned city
That is in
council.
what point? This decision?
But with regard to section 5A, but section 15 is as good as section 15. But we also find merit in the argument of the learned city council for the appellant that the declaration issued by the state government was vitiated due to violation of the section 5A represents such. Right. And may I come to para 21-22. It is section 5A which embodies the most important dimension of the rules of natural justice. Lay down that any person interested in any land notified under section 4.1 may within 30 days of the publication of notification submit objection in writing against a proposed acquisition of land or any land in the locality to the collector. The collector is required to give the objector an opportunity of being heard, either in person or by any person authorized by him or by pleader. After hearing the objection and making such further inquiry as he thinks necessary, the collector has to make a report in respect of the land notified in such with his recommendation on the objection of the and forward the same to the government along with the record of the proceedings held by him. The collector can make different reports in respect of different parcels of land proposed to be acquired. My lord, so this is it is a mandatory requirement. Now I come to my lord, I will not take other paragraphs are a reiteration of this, my lord. And I come to last para 32, my lord. This is the same judgment. 32. It reads, my lord.
Yes.
In the result, the appeals are allowed. The impugned order is set aside, and the declaration issued by the state government under section 6(1) is quashed. However, it is made clear that this judgment shall not preclude the state government from taking fresh decision after objectively considering the objection filed by the appellants under such and such. If the final decision of the state government is adverse to the appellants, then they shall be free to challenge the same before an appropriate judicial forum and urge all legally permissible contention in support of their cause.
So this is not a case of quashing the entire proceedings?
Yes.
6(1).
Yes.
It means section 19.
Yes, section 19. Section 19, and government is the liberty, and if they give me, I can address my issue, and if it is adverse to me, I have a forum.
But then here, your challenge is to the entire proceedings.
In that proceedings, my lord, in that proceeding, but mainly, my lord, violation of the section 15, and ultimately, my lord, my main challenge is section 19 is not sustainable. So if lordship takes away section 19, then the section 11 will be remained for the time being, my lord. And section 9, since 11 is there, they may give me opportunity under section 15. I would address my grievances there, and collector will hear me, send a report to the government will take a final decision which may adverse to me. But that entire record before the collector and government will be part of the record before the reference court. That is a normal procedure, lordship is away. When my matter refer to reference court, it will be part. But otherwise, my lord, without hearing me, if I go straight away to the reference court, my lord, I did not agitate any point before the collector and the government. Therefore, hearing under section 11 is very essential. Sorry, section 15 is very essential. That become part of my agitation before the reference court. And the reference court will definitely take a decision, my lord, in accordance with. So this one decision, so to persuade my lord that lordship can quash. The moment lordship comes to know that section 9 plus 11 is binding. Another judgment, my lord, may cite 2012 volume 2 SSC. Which,
also on the same point.
My lord, it will further elaboration of the this point.
Is it required that on the same point you give so many things?
My lord, this it may read out, my lord. High Court can quash the section 6 if section 5 is not complied.
2012?
2012, my lord, volume 2 SSC, page number 25. Relevant para would be, my lord, 13 to 29. It says the, my lord, section 5A is a mandatory provision.
13 to 29?
Yes. It's a mandatory provision. So I may not take a lordship for that.
All your decisions say the same thing.
Yes, yes. Another decision which I've given the lease, my lord, that is 2016 volume 14 SSC, page number 746, my lord.
Yes.
Well, this lordship allow me to take lordship attention to this. Page number 746. Only one para 9 I would refer, my lord. A lot of question arise in the when lordship start hearing the matter, lordship put forward a question to me whether if I convince my lord, lordship can set aside the entire acquisition exercise. For my lord, here the Honorable Practice Court respond. Para 9 lordship allow me to. Prima facie, time for filing of section 5A objection would have to be computed to have commenced on the date of the order and such. And further, there seems to be no alternative but to deem the issuance of section 4 notification for the same thing. Hence, the section 6 declaration would have to be made at the latest by such. However, we reiterate that the High Court ought to have simply quashed the section 4 declaration in pursuance in personam, or if circumstances so commanded in writ, by permitting or enjoining the petitioner to file objection. The High Court has caused a frequent such position to come into place. But as a threat, no party can be made to suffer any disadvantage due to act of the court. The not respondent file objections and such, which were dismissed and such, paving the way for passing up the fresh sections and such. The respondents thereupon challenged the sections and such, and sections and such. My lord, here, if I read properly, here also section 6 was quashed in person. So in person. So in my case also, many thousands of landowners are there. I have no business to canvass their votes before this court. If Lordship satisfied with regard to the petition, present existing petitioner, Lordship can even quash in connection with the petitioner themselves. Now another judgment, my lord, may I refer. Now the earlier occasion, the other side, my friend has referred to the interim order passed by this court. And in view of that interim order, subsequent action take place. And the ground of my challenge appears to be vanishing in the course of time. Now, I would refer, my lord, to a few judgments. Before I go to that one, my lord.
How many judgments?
My lord, the 3-4 judgments are there. Your Lordship allows to conclude.
No, you see, it is not that. If you find that this is relevant, if you give judgment, the court is bound to take into account. But then, if it is on the same point or the repetition of the same point.
Well, I hear one decision. Now, with regard to section 11, section 15, I will not cite further authorities. Now, I may allow to cite with regard to the stand of the collector. Now, the collector do not represent the state government under the LA Act. He is an impartial arbiter between the government and the interested person. He has to exercise his statutory power. Therefore, my lord, the affidavit filed by the collector do not carry the voice of the government. Now, what he has done.
Your contention here is that the collector has not acted as per mandate of
my lord, that is one thing. So, in second part, he says that he raised the title. He is raising the title that the land doesn't belong to the petitioner, it belongs to the state government. He raised all these things.
This court will not go into those questions.
Therefore, my lord,
right from the beginning, this court has indicated that if it comes to determining that who owns what part, and then see like what compensation should be paid by taking which part of land, this court is definitely not going.
That's correct. Since he had raised that one, I want to bring my lordship attention that collector cannot raise this issue. Collector do not own the property. Here, admittedly, state government did not file an affidavit. If the state government file an affidavit claiming the disputes, then that becomes a dispute question of rights between the parties. Here, state admitted did not file an affidavit. Merely collector raising that issue, that will not cannot be considered as a dispute on title also. So therefore,
collector can file an affidavit showing compliance of the provisions of law.
Yes. His duty is that I have complied. That he has to demonstrate that part.
Right now we are concerned with that part of it.
Yes. Well, so with regard to that affidavit, I will not read, but I'll just cite that judgment. Well, my lord, 2005, volume 7, SCC, page 6 to 7. Relevant para would be para 17 to 18.
You have given a list of books?
A list of books I have given. I may not take a lordship attention. Where it says, my lord, that state cannot be represented by the collector. Because the business of the state do not endorse the collector to file an affidavit with regard to land acquisition. He is a separate authority under the Act. Therefore, the issue raised by the respondent, the collector, in his affidavit with regard to titles and other validity of the patas, my lord, he is not competent to raise those issues.
But then here your contention is your case is against the collector also.
Yes.
You say that he has not discharged his role.
Yes, correct. And in one of the affidavit, the minutes which I have challenged, he says that ROW, the landowner has no right to claim the compensation for ROW. Now that ROW was raised by one of the NOCMA in one of the meetings. So NOCMA came and informed him that ROW landowners are entitled he adopted the resolution minutes that the question of payment of compensation to those landowner with regard to ROW doesn't arise. My contention is that, my lord, that order is...
He could not have made that.
Yes, yes. Without issuing notice to me, he has taken away my rights. And he is deciding the status of the ROW. At best, he could hear me and send to the government. So that is what, to that extent. Another point, my lord, with regard to the interim order, now,
yes,
my lord, with regard to the order passed by this Honourable Court initially refusing to stay the notification, I just request Lordship to recollect 2 orders only. The first order passed by the...
These orders are already part of record.
It is part of the record, but for easy reference, Lordship, I refer 7/8/2022. Now, my lord, the learned single bench rejected
You have given me as a copy of 16/12/2021. Order date 16/12/2021.
Yes.
You have given
order date, my lord, first 7/8.
Yes, 7/8.
7/8 is the first order we filed. We moved the writ petition.
Yes.
Now, my lord can see the nature of the order. Now we start from the second page. Having heard, my lord, having heard the learned counsels on the interim order matter and given my thoughtful consideration to the prayer of the petitioner, it is noticed firstly that the widening project, by the own statement of the petitioner, have commenced since the middle of 2019. The petitioner have come before this court only after the impugned declaration such and such, under such and such was published, by which their estimation has excluded other sizable proportion of the land. As per the declaration, the hearings were already concluded as per sections. This is incorrect as per the record. Even the collected record do not show that hearing concluded. The report of which is annexed as such and such of the petition. Looking into the facts and circumstances as they stand at this stage, the petitioner having approached this court after considerable period of time after commencement of the project, the question of any orders issuing to suspend the same does not arise and prayer is rejected. However, if it is significant, however, there is a significant removal of trees and also some demolition of structure from the project site. It is expected that the respondents or the agency engaged in the project maintain a record as to the specific areas from where the number and size of trees have been felled and removed, and also keep records of the location of the pergola structures which have demolished in the course of widening the highway, which will be subject to, it's important, subject to further orders to be passed by this Honourable Court. My lord, it is not a blanket, my lord, a total rejection of my prayer. It is a conditional order that if you want to proceed further, you proceed. But you maintain the records with regard to the structure, the trees, and the area where you do. Immediately after this order, they did not proceed. This was the order. And after that, my lord, they filed the NHITCL, Breathing Agency, has filed this case, and Lordship, this Honourable Court has passed the order, the next order, 16th. Now, they come up with the allegation that the landowners become an obstacle for implementation. Then we clarify, and thousands of landowners were there. Their general statement was there, and they also say that the petitioner also part of them to become obstacle in the land acquisition process. Matter was taken up, arguments were recorded, and the order was passed. My lord, you can kindly see para 4 of the next page. Mr. Sen, learned GF for the respondent opposite party submits that the difficulties that had arisen is due to the fact that some of the landowners and owners of the structure along with the highway did not agree. His submission that they even not target the petitioner with the amount of compensation, and being discontented had refused to cooperate with the district administration, which have resulted in the delay in handing over of the ROW in few stretches. As such, he submits that if the landowners do not object or cause obstruction, there would be no impediment for district administration to hand over the ROW to the applicant corporation. I have heard the learned counsel for the parties and given my thoughtful consideration to the matter. I have also seen the order dates and such passed by this court, which has rejected the prayer of the petitioner who prayed for suspension of the notification and further construction pending settlement of the compensation. As the prayer for suspension at that point of time had already been rejected, the petitioner should abide with the order of this court and not cause disturbance and allow the project to continue as the matter is in public interest. Furthermore, as stated in the affidavit, the process of compensation is still not complete. It is expected that the petitioner be given a chance to be heard and present their case as and when they are called upon by the district collector. Now, this, my lord, if I understand properly, if you proceed further and ready for paying compensation, that means after proper assessment, after issuing sections 921 notice to all of them, heard the matter and make an assessment, you give them opportunity to be heard. That is ultimately under the Act, that is section 21, right to be heard. But it was not done. Not done. Now, misapplication is accordingly disposed of with the direction that district administration within the shortest possible time shall facilitate the handing over out of the PDP in HITs here, and the petitioner shall not cause any obstruction. It is expected further that the records of the land as it is directed by the court, by the order itself, shall be maintained by the respondents. The order is very, very clear, very clear. Therefore, they have to maintain the records. You proceed in accordance with it. Accordance with it. But everything is subject to the outcome of the petition. Now, in my case, my lord, this order was passed in 2021.
Yes.
And they did not take any steps. And when Lordship took the matter for first time for admission hearing, the Lordship granted 2 weeks time to the learned GA to ascertain how out of 90, how many of them has received the compensation. To ascertain that one. Now, instead of ascertaining that one, what DC has done, collector has issued a eviction notices. Issuing eviction notice means that he is yet to take over the position. Now I would show he did not issue section 21 notice. I'll cite the authorities. If section 21 is not given, a word is also invalid. I'll cite the judgment. Now he did not issue. He straight away issue eviction order. In fact, it is a violation of the court's order, but the party doesn't want to complicate the matter. They were at one point of time willing to file a contempt against the collector himself. But my lord, to expedite the hearing of this main matter, my lord, they did not file the contempt as of now.
Initially, how many writ petitioners were there together?
90, my lord.
And then how many have been deleted?
Now 44 of them deleted and 46 are remain here.
44 have been deleted.
Yes.
By just one order, same order.
Well, separate order, 3 orders are there.
What are the routes of orders?
My lord, I will. Yes, my lord, the first order was passed on 16/4/2021.
Yes.
Lord Speaker, I didn't note down.
How many were?
It is 16/4/2021. In miss case number.
Yes, how many were deleted?
Only one petitioner was deleted. Writ petition number 17 was deleted. Miss case number 27/2021. And thereafter, my lord, order dated 14/3/2024.
Yes.
Well, 24 passed in miss case number 32 of 2024. Writ petitioner number 52 and 54 were struck off.
2 persons.
2 persons were struck off.
And then?
And later one, my lord, the recent one, in this case we find 41 writ petitioners were struck off. By
order dated? Two 9 24.
Yes, 29. So 41 of them were struck off.
All on the ground that they have received compensation.
Yes, yes. Right or wrongly, they received. So the death wood has been removed. Only 46 of them are here.
Yes.
Yeah. No. So this is the nature of the order passed by this court for the ends of justice at that point of time. So last time the argument was advanced from the other side that even if there is an infirmity in the previous proceeding, but in view of the fact that land acquisition process continued, so my ground may not be sustained now at this point of time. I would cite a few authorities where, my lord, the may take a 2011 volume 5. 2011 volume 5 ACC page number 142. 142. Relevant para would be my para 32 and 34, 33.
Yes. What does it say?
My lord, para 32 and 34, 33. Right. It is thus, my lord. 32 and 33.
That is a service law jurisprudence.
Service jurisprudence, but my lord, it applies to all the administrative orders and the judicial orders. That is the principle. Fact of the case will be different. The principle. Well, it is a settled legal position that if initial action is not in consonance with law, subsequent proceedings would not sanctify the same. In such a situation, the legal maxim such is applicable, meaning thereby, in case a foundation is removed, the superstructure falls. In such case, this court observed that once the basis of a proceeding is gone, all consequential action, orders would fall into the ground automatically, and this principle of consequential order, which is applicable to judicial and quasi-judicial proceeding, is equally applicable to administrative orders. According to me, therefore, I'm urging that if Lordship finds that my lord, the previous proceeding of the collector, non-adherence to the section 15, resulted into my deformity in the section 19 declaration, if it is illegal, and the consequential order he has taken after filing of the writ petition will not sanctify. Imagine, my lord, otherwise citizens come before this honorable court challenging the action of the authorities, executives, and the matter proceeded, well, even without interim order also. They cannot come and say, oh, during dependency I have taken all my steps. The step I have taken during dependency is full of holistic in nature. So don't look back before the action I have taken before you come to the High Court. In that case, no action of the executive will be challenged. Citizens will never get the justice. Therefore, my humble submission is that if the initial action of the collector, acquisition proceeding, is illegal, your subsequent action,
the initial wrong cannot be corrected subsequently.
Yes. My lord, court is. And another judgment with regard to this, my lord, may kindly see 2010 volume 9. 2010, sorry, I'm standing corrected, 2010 volume 9, ACC page number 437. Relevant para would para 19 and 20.
Yes. On what?
My lord, the consequence of a passing interim order. My lord.
This is also administrative law.
My lord. May I start for para 17, 19 and 20. My Lord, para 17. In the Southeastern Coalfield Limited versus State of MP, this court examined this issue in detail and held that no one should suffer by an act of the court. The factor attracting the applicability of restitution is not the act of the court being wrongful or a mistake or error committed by the court. The test is whether an act of the party persuading the court to pass an order held at the end as not sustainable has resulted in one party gaining an advantage it would not have otherwise earned, or the other party suffering an impoverishment which it would not have suffered but for the order of the court and the act of such party. There is nothing wrong in the parties demanding to be placed in the same position in which they would have been had the court not intervened by its interim order. When an act of the proceedings, the court pronounced its judicial verdict, which does not match with and countenance its own interim verdict. The injury, if any, caused by the act of the court would be undone, and the gain which the party would have earned unless it was interdicted by the order of the court would be restored or conferred on the party by suitably commanding the party liable to do so. Any opinion to the contrary would lead to unjust, if not disastrous, consequences. And I have come to 20. Therefore, such judgments are passed in the application of the legal maxims and such, which means that in case foundation is removed, the superstructure falls. In such case, this court observed that once the basis of the proceeding is gone, all consequential acts, action, orders would fall to ground automatically, and this principle of consequential order, which is applicable to judicial and constitutional proceedings, is equally applicable to the administrative orders. Therefore, my Lord, my humble submission is that the respondent cannot say that due to interim order, I have taken decision, I have taken the further steps. Therefore, whatever illegality earlier, petitioner cannot question, or in other words, court cannot.
Is it their case that they have corrected?
That is how they are projecting, my Lord. That forget about the past. Interim order was given, stay order was refused. Rather, I was allowed to proceed further. So whatever I proceed further now, you can't look back. That is what they are trying to project. That I have
But they do not say that the deficiency of, non-compliance of section 15 has been corrected by subsequent act. That is not that.
That is not the one. It remains the same. But what they are trying to project is that what happened already happened. Now, what happened now during the pendency, in view of the court's order, I have taken certain steps. These steps taken by me during the pendency, court cannot look into or interfere, or petitioner cannot urge the court to look into. That is, according to me, my Lord, by this judgment, it is incorrect. Whatever interim order is there, the judgment says that if a person enjoy advantageous position when at the end of litigation, the court comes to know that initial action is wrong. In that case, the party cannot claim any advantages. Here, the respondent tried to claim advantages by virtue of that order. And similar judgment, my Lord, 2004, this will be last second judgment.
On the same proposition?
My Lord, yes, my Lord.
Subletter fundamental?
Yes. 2004, volume 2 SEC. Page number 783.
Volume 2 SEC?
Well, 2004, volume 2.
Yes.
SEC, page number 783.
Yes, para?
783. Relevant para would be, my Lord, para 7-11. But I will take only one or two paragraph only. Well, I will take only to save lordship time. I will take only para 11. Well, so lordship, keep in mind the other relevant para. Para 11. In the facts of this case, in spite of the judgment of the High Court, if the appellants would not have persuaded this court to pass the interim orders, they would not have been entitled to operate the mining leases and to raise and remove and dispose of the minerals extracted. But for the interim orders passed by this court, there is no difference between the appellants and any other person raising without any lawful authority any mineral from any land, attracting applicability of such and such. As the appellants have lost from the court, they cannot be allowed to retain the benefits earned by them under the interim orders of the court. The High Court has rightly held the appellants liable to be placed in the same position in which they would have been if this court would not have protected them by issuing interim orders. Now here also, if we see the fact of the case, the party obtained some interim order in joy, and ultimately when the matter finally examined, his claim was found to be illegal. And therefore,
it is dependent on the end result.
Yes. Therefore, the Supreme Court said that no, that interim order is there. Under the shadow of interim order, you have taken some step. That benefit, you are not entitled. You are not entitled. Same thing, my lord, whatever order passed by this court, under that protection or shelter, collector may have taken some steps. Yes, making assessment, giving a word to somebody else. But that could not give them any advantageous position to, my lord, avoid answering to his initial illegal action. Now, the last, my lord, citation 2011, volume 5.
2011?
My lord.
Yes.
11, volume 5, ACC, page number 553. Many times the respondents say that public interest is a holistic interest. Therefore, court should not interfere. Citizens should not question. It is for the progress and growth of the citizen. All this they argue in this way. But the apex court held, well, with regard to land acquisition, the sanctity of the provision. 2011.
Yes.
2011, volume 5. Well, page number 553. Well, this also with regard to land acquisition. I may come to para 77, separa Para 2, 3, and 4. Para 77.
Yes. 2, 3, and 4.
Well, yes.
Yes.
Well, it reads thus. Well, the legislation which provide for compulsory acquisition of private property by the state fall in the category of expropriatory legislation, and such legislation must be construed strictly. Though in exercise of the power of eminent domain, the government can acquire the private property for public purpose. It must be remembered that compulsory taking of one's property is a serious matter. If the property belongs to the economically disadvantaged segment of the society, or people suffering from other handicaps, then the court is not only entitled but is duty bound to scrutinize the decision of the state with greater vigilance, care, and circumspection, keeping in view the fact that the landowner is likely to become landless and deprived of the only source of his livelihood and shelter. The property of a citizen cannot be acquired by the state or any other agencies or instrumentalities without complying with the mandate of Section 4, 5A6 of the Act. A public purpose, however laudable it may be, does not entitle the state to invoke the urgency provision because the same have the effect of depriving the owner of his right to property without being harmed. Only in the case of real urgency, the state can invoke the urgency provision and dispense with the requirement of hearing the landowner or other interested parties. But so the seriousness, the importance of the legislation is reiterated here.
Particularly 4, 5A and 6.
Yes. So what I want to, my lord, emphasize here, that this is, my lord, section 15, is the only one of the main window for the landowner or interested party to place their grievances before the authorities. And this is very important one, and it can be construed very strictly. Now, my lord, if lordship permits me, may I take the averments up between the parties with some annexures? Some annexures. Now, my lord, in my writ petition, specific averment has been made with regard to, my lord, section 15, right to be heard.
Para?
My lord, may kindly note para 20, 26, 65 and 74. These are the relevant para with regard to opportunity being heard.
If you kindly repeat the paragraph.
Paragraph 20,
yes,
26, 65 and 64.
Yes.
So 74.
Yes.
This is with regard to opportunity being heard in section 15. Now the reply of the collector, we would see, my lord, he did not deny. Para 21 and 44 of the counter affidavit of collector. I would take lordship attention to that paragraph.
Counter affidavit dated, what is the date?
Affidavit we received on 3rd November 2021.
How many affidavits are there by the state?
He has filed only one.
Only one. So
Only
there
one.
is no problem. So
Yes.
counter affidavit by the state. Is
Yes, by the collector.
Yes.
State did not file.
Yes, by the collector.
Respondent number 12 and 13.
You are referring to para?
I refer to his reply, para 21 and 44.
Yes.
And my lord, kindly see the nature of his response. Well, first, para 21, lordship, can you see?
The files have become too thick, Mr. Sandwich.
Well, Lord, it is very, very, very thick. The thick annexures. Thick annexures. And affidavit is thicker than the writ petition. We have an illustrious collector. He is the author of all the documents.
Collector is respondent number?
12 and 13. 12 and 13.
There's a 447 pages affidavit. Yes. Para 21.
Para 21.
These pages are already deleted. Is that difficult?
Some pagination error is there, but anyway, repeatedly para 221s are there, but anyway, it's unintentional. Lordship, can you see para 21? Running page 10 of the counter.
Yes.
It says, in reply to the statement made in para 20, it is stated that the averments in the writ petition established that the petitioner were not aggrieved with the alleged non-compliance of the provisions of the Act of such as being projected in the instant petition rights, whereunder the petitioner had waived by their conduct in cooperating and participating in the negotiation process. The actual grievance of the petitioner is denial of their claims over the areas covered by Clause 4 of the padas, over which they have no entitlement in law. The petitioner have misguided and motivated into asserting a right over the said areas as to inflate the amount of compensation. It is reiterated that petitioner have all along accepted the terms of the pada accepted by the JDC and have recognized the leasehold nature of the properties. However, petitioner have now chosen to question the said pada or lease before this court, and such a challenge cannot be sustained or maintained in the proceeding of the such. So he is not denying about the right to be heard. And another para, Lordship, can you para 44? running page 19.
Yes. The summaries of pages here are torn, is mutilated. It's very difficult.
Para 44
Yeah,
at the
40,
bottom.
yes.
The statement made in para and 64 have suitably addressed in the following paragraphs, and the answering deponent seeks to avoid repetition. So throughout his affidavit, he did not say that yes, I received the, or I did not receive the objection, or I received it, I addressed already, I have recorded the objections, prepared the reports and recommendations, and sent it to the. He never. So it is he admitted that there is a non-adherence to this. That he simply said that we are participating. In what way we are participating? He did not hide it. We did not hide. So this is one of his response method. And he had, my lord, I would show, my lord, the annexure he made. His annexure, if you can see. Annexure 3, page number 26 of the counter affidavit.
Just this paragraph, there is no denial by the connector.
Yes.
That he has not, you see, like heard you.
Yes.
Disposed of your objection.
Right. Yes. On that particular day, they,
yes. What annexures?
Annexure 3, page number 26. There is a report prepared by the.
Just go slow. These pages are in a terrible condition.
Yes. Page number 26, annexure 3. This is social impact assessment report prepared by the respondent.
Yes.
Now, I may come to the relevant one just to show the background. This report was prepared on December 2018, page number 28. Page number 28.
Yes.
My lord. And my lord, can you come to page number 38? What is ROW at the time of the social impact assessment?
Yes.
ROW, right of way, Lordship, can you see in the middle of the page? The width of the existing road is about 4.75 meters. This shall be enlarged up to 10 meters, including road soldiers. The land to be acquired is such and such and such. So the assessment on the ground, existing road of the single lane was 4.75. Now they propose to extend 10 meters. So more than 5 meters, they are projecting that this is ROW. Now apart with this, my lord, they have also, government has also appointed expert group, and the same finding.
You are going into all those things.
But
what finding this court will record, you say?
Just to show the background, what is the grievance of the petitioner? If the collector gave me opportunity, we would have addressed this.
If your grievance is that you have not been afforded an opportunity in terms of section 15, then where is the occasion to come to all those things? This means this will concern the rate and the area.
The area, the concern with the area.
So what? See, is it a kind of, say, alternative argument? Now your objection to the acquisition proceeding is because that your claim for inclusion of ROW has been denied. Now, and on this ground you are seeking, you say, like the quashing of the proceeding. That is not your case.
That is I am just highlighting the nature of the road at the time of initiation of the process.
But then if you
Only
adopt
for
these
that purpose.
two lakhs of argument, then again, then where we end up?
No, no, my lord, I'm not canvassing, my lord, to urging my lord to return a finding on the ROW. No, I'm just highlighting the background matter. For the time being, my lord, will lordship permit, I'll skip that one.
Now, if you,
Then we come to the
will you be happy if this court holds that you are entitled to get compensation for ROW?
well, that was
Then your other part, the non-compliance of section 15.3, you are ready to concede. You're saying that it is not required.
That is the main grievance. Yes, that is the end result grievance of the petitioner only. Because the larger chunk of the land in loss.
Ultimate is the thing is that the compensation.
Yes. Right.
Compensation for ROW. That is what your claim is.
Right. But that is a grievance. Now the section 11 and section 19 declaration.
Now 15.3 contemplates your objection against the accusation.
Yes.
It has nothing to do with the rate.
Right.
So then is it not that you are taking two contradictory stand in your argument?
No, the section 15A 1.2, I have the right to raise the objection with regard to the area of the land. Because the inquiry under section 15 is limited. Collector cannot expand to different subjects.
No, but see, but for that opportunity to lodge your objection is provided. Why?
Yes.
If you have anything to say against the accusation, isn't it? That means you are opposed to accusation.
Yes, yes. Right.
So now your opposition is not because of the rate or the area for which you see like they assess compensation. Can it be? Can you say that since they have not given me this much rate, I am opposing this? Then in such a case, your objection doesn't come under section 15.
Right. Cause is not involved. Cause is not involved.
So then in such a case, we can say that you have not filed any objection under 15.3. Your objection pertains to something else.
Well, I'll come. The objection is
now, if you adopt the second level argument, if you refer to ROW and all, then only that situation comes. That is what the problem is. You see, like then otherwise you see like if you tell the court to give findings on both the aspects, court can give finding, but then where you will stand?
No, my lord, ROW, my lord, whether 3 feet, 5 feet, or 7 feet, ROW, lordship cannot return a finding. I'm not urging for that.
Not going at all those.
Yes, yes.
Whether it is 5 feet, 10 feet, 12 feet, see, is not our concern.
Exactly.
We are concerned with the argument which you have.
Right. But therefore, I cannot go for the complexity of the ROW, the area also. So also the collector or the respondent also cannot raise the disputed, the titles, possession, and others, validity of the pada. That is not the point canvassing between the parties. Here, mainly but procedural fairness, that is imbibed in the act itself, whether that fair procedure is complied with or not. If it is complied with, I have no merits.
That is fine. That seems fine. That is okay. That contention is okay.
Right.
But then if that your argument is coupled with the argument which you are raising right now, okay, taking it together with your contention that the collector has no power basically to decide whether ROW you are entitled to get compensation for ROW or not. Now, if you go into those questions, then probably your other argument about the challenge to the acquisition proceeding would not stand.
My lord,
if it is based on that.
My lord, what I am trying to impress upon my lord is that collector can hear me, but collector cannot reject my objection. Whether my objection is valid or not valid, it is for the government to decide.
That is understood.
Yes.
But then,
and my objection would be area. And when we talk about area is mentioned in the section 50.
So, so far as collector is concerned. Now you are yes. Now in court you are raising this question of ROW. And that is in relation to your claim. You see, that you say that yes, I am entitled to this much amount for ROW, or this much I should be getting. You see, like compensation for this part of land.
Right.
Now, if that be the thing, then we can say that we do not have any objection to the acquisition.
But therefore, my lord,
Subject to
I'm not
the payment as expected, subject to the payment which you expect.
right. Therefore, I'm not with regard to that. I'm not pressing my lord to give a return that I entitled for the ROW compensation. I'm not pressing for that. Here we are confined purely to the procedure adherence.
Exactly. That is what you argued on.
Adherence only. Now, if lordship allow me to take the
what else?
My prayer portion. I'll come to that counter affidavit.
Why it is relevant?
The prayer portion, my lord, the prayers we have made, but I need to clarify some prayer portion.
Where is that? Where is
Page
the
number, my lord, 84J of the writ petition.
Your affidavit contains what document, Mr. Shen? Why it is so voluminous?
The SIA report is quite voluminous, man. The social impact assessment report.
What relevance it will have here? It will have.
There was a challenge to the entire proceeding, so that was brought on record, my lord, at that time.
Yes.
My lord, may kindly see my prayer in the writ petition, page number 84J, page number 84. 84J.
Your prayer is another petition.
Prayer. Well, I'll come.
That is like another petition. Length of the prayer is like another petition, isn't it?
Well,
how many pages prayer? Okay. It is only
three pages.
three and a half pages. Yes.
Yes. My lord, may kindly see 84J. First prayer, my lord. The impugned minute, 3rd October 2018, adopted by the collector. Here I would show he has taken a decision that the payment of compensation for ROW doesn't arise. And without hearing me, he has taken a decision unilaterally. So I challenge that setting aside that one. Second prayer is impugned preliminary.
At what stage he has taken the finding? At the stage of that 15th. This 3rd October 2018.
Yes. My lord, before he preliminary notification, he has taken a decision behind my back.
Okay,
and that was the foundation for the government to issue preliminary notification. Yes. And that one is a preliminary notification. On the basis of the collector report, his decision that ROW is not required for compensation,
yes,
government has issued section 11, pre-notification. So we challenge. So the third one is, my lord, the impugned report of alleged section 15 hearing on 16 October 2019 onward submitted by the extra assistant commissioner. I would show that one also. There was no hearing at all. I'll show the materials are there. I challenge. And the other one, my lord, 4 is impugned letter issued by the district council. I will show there. They say that with regard to 35 feet from the center line of the public land will not be counted for compensation.
It is JJDC, isn't it?
JJDC.
JJDC has nothing to do with accounting. So which these are not relevant at all.
My lord, here I will show on the basis of this very letter, collector has reached a conclusion.
So that is your first prayer.
Yes.
If first prayer is allowed,
yes,
this will take care of this.
My lord, it will take care. So that is another. And fifth prayer is declaration, section 19, which I, my lord, humbly seek for quashing, because of the section 15 is not adhered to. And the subsequent prayer, my lord, I will not press, because once lordship set aside the quash the section 19 declaration and the DC minutes and others, ultimately I would have the opportunity before the collector, and I would address my grievance there. So I have reserved my right to press this later before the appropriate forum, since the lordship we are confining with the procedure of fairness.
If the quashing proceeding goes, then this prayer would not be there.
Right. Therefore,
there is no opportunity for you to
once it is quashed, my lord, and if they don't proceed, then matter ends up there. But if they want to proceed further, then my subsequent prayer made herein, I would address before the collectors. Okay. Now, lordship, can you see the
some more? Oh, still you have anyway. It's okay. It's all right.
The averment, the pleadings are very, very bulky in nature. Therefore, it is my duty to address few important ones. Otherwise, my lord, lordship has given me a patient hearing. I appreciate for that, but nature of the pleading is such that it covers.
Say senior counsel is speaking, we cannot shut him down. You see, so long he finds that he has done justice to his work. Yes, please.
All of you, I'll try to concise it as far as possible.
What you are trying to point out from the
page number 86.
What with regard to what? What would be your
with regard to the pata issued by district council upon which collector is solely relying.
All those things.
It's okay, my lord.
It is not at all relevant.
My lord. But let us not go with that, my lord. I'll show the first impugned order. I'll go to the impugned order straight away. But page number 108.
Yes, Mr. Dr. Majika, you said something. That is basically a question of law here. That is what we understood. Right. Nothing else. But then
I have to show the impugned order.
What is the page you said?
Page number 108.
Yes, annexure 11.
Yes, annexure 11.
Yes.
In the middle, I'll point out, my lord.
Yes. Please.
My lord, in the middle, one of the Aking Nokma asks the Deputy Commissioner or the PWD department whether the so-called ROW has been acquired by the concerned department and whether any compensation has been paid to any of the Nokmas or the landowners. He said that the road has been surveyed twice initially. My lord, the road was a survey
twice,
twice, yes.
After full stop, then initially.
Yes, initially for 30 or 15 meters from the center line. Later, the road was resurveyed, bringing it down to 20 or 10 meters each from the center line, which has caused a lot of confusion, even bringing misunderstanding on the Aking Nokmas by the landowners since they have cooperated with the survey group. He also desired to know whether those whose instruction the road was surveyed and resurveyed as per this and such. In connection with the question asked by one of the Aking Nokma, the Deputy Commissioner said that the ROW is being followed based on the Assam Land and Revenue Regulation, which is also being followed by the JDC in their land. But as even now, therefore, the question of compensation should not arise. So he has taken the decision that question of compensation. I have agreed.
It is not for him to say.
Yes, he decided.
At all, see, you make a claim and then why it is rejected, why not rejected. Basically, it's done by referee.
Right.
Whether it is ROW or not ROW, I don't think he may have it. But then you see, like your case here is something different.
My bad. Therefore, I have a limited grievance over there that he has decided unilaterally behind my back. Now, may I come to, my lord,
Now, you see, Mr. Shangreshu, now if you want us to interfere with that finding of the collector, that ROW, that no compensation is required to be paid for ROW, then what happens? If you interfere, does it mean that you become entitled or compensation ROW? Can you say it at this stage?
My humble submission is that only the minute can be taken away, but whether I entitled ROW, that is the absolutely different issue. Only Lordship will set aside in view of the violation of the principle of natural justice. Collector has decided by himself without giving opportunity to the landowners.
See,
only to that extent.
If your opportunity for raising grievance against the rate of compensation or the apportionment or the measurement of area, see, this has to be decided by a different forum, isn't it? Now, whether his finding is there or not there, it will be subject to the finding which is arrived at by the concerned authority, isn't it? Now, that comes at a separate stage. Now, again, the same question comes. Can you maintain then both the things? Like your challenge to the acquisition proceeding, and at the same time your challenge to the amount of compensation.
No, my lord, I'm challenging the minutes. Whether I entitled for ROW or not, EC cannot
I
finally
can
decide.
understand ROW, that means see, your entitlement for ROW basically is with regard to the amount only, not the rate. If ROW is included, you get more money. If it is excluded from your thing, you get less money. But then that is basically, it has to be, if you allow if you allow this proceeding to continue, then
Therefore, whether I entitled for ROW or not, that would be a different forum, is there? But collector, my limited grievance, the collector cannot take a unilateral decision behind me, behind my back. And the question of payment of ROW, that's not right. That is violation of the nature of justice.
I think there remains, there will not be any true opinion with regard. That has to, your compensation, your rate of compensation, or the total amount of compensation, the basis for arriving at, that stands as a different.
Limited to extent, I challenge at the minutes of the collector. Now, my lord, I'll come to section 11, notification. I'll show and come to my objection paper.
Where is the section 11?
My section 11 notification is available, page number 113, annexure 15.
Will you be able to conclude it today? We don't think.
I'll be very brief, my lord.
Huh?
I'll try to be as brief as possible. Since my learned senior is confining this whole case to section 15, I'll confine myself to section 15 itself. Only on that issue.
Mr. Shangresho has not confined himself only to section 15.
That's also
beyond to ROW also.
Lordship.
Anyway, that is okay. That is okay. It's all right. Just let us know because
Page number 133.
133. Yes. What are these photographs, Mr. Shangresho?
My lord, what happened after issuing this? The collector in certain stretches of land they started clearing and falling down the trees. Most of the land of the non-petitioners.
After filing the writ petition or after?
Before. And there 2-3 writ petitioners were there, their land are there.
Yes, 133, yes.
Most of the landowners they did not approach before this court.
Yes, page 133.
Yes. Now thereafter, we filed an objection, page number 187. My objection.
133 is what?
Is a section 11 notification.
Okay.
And may I come to, this was published in fact on 11 July 2019. But in any case, my lord, this was reflected in the record 27 June. Publication was on 11 July. Now, may I come to the names of the repetitions are mentioned. I will not take, my lord, I urge lordship to take the trouble. I may urge my lord to come to my objection.
Yes, where is that?
My lord, page number 187.
Yes.
My lord, in the content of the objection, para 1, 2, 2, 3, 4, the issue of the, my lord, the ROW, the PADA issued by the district council, we explain what is the nature. So had the collector heard us, that this would be placed before him, collector would prepare a report or recommendation on the basis of this objection as well, and the government would have applied its mind more reasonably. But admit the fact is that he did not take up. He did not.
Yes.
And my lord, I may go to another. Then thereafter, what happened, my lord?
You are still not in a mood to finish, Mr. Shangresho.
My lord, I have to show some certain annexures with lordship permission.
Yes.
Now, my lord, page number 218.
Yes.
218. This is notice under section 15.
Yes.
Well, this is for information of the concerned dogmas and landowners that the hearing under section 15 of the Act, which is in connection with the claims and objection pertaining to the acquisition of land from widening of the Sunsuch, would be held from 16 October to 28 October in the office chamber of Sunsuch. So he has fixed. Well, the writ petitioner concerned here, serial number 2, 3, 5, and 6. their lands fall there. Now notice was given, it was fixed.
Writ petitioners are two.
Some of the writ petitioners fall under serial number 2, Kanolgri King,
Yes.
Jasin Gri, Magongri, and
2, 3 and
2, 3, 5, and 6. And they fix 16, 17.
This 4 King take care of all the petitioners, all the writ petitioners.
Yes, they said they issued, they mentioned this, they don't issue this to the individual.
Okay, so there was
landowner.
the issuance of notice under section 50.
Yes, right. They said they have issued this, but none of the petitioner received any notice. And my lord, we kindly see.
What is the manner of issuing this?
My lord, in fact,
which way the law says it should be ensured that the recipient has received it?
My lord,
because this is not individual.
Not
in the
individual.
name of a king.
Yes. And now what happened? The hearing is available in page number 20 or 220.
This is a hearing.
Hearing, they say. Hearing. And those, how many of them appear also? Report on the hearing, Lord Majesty.
Yes.
Conducted under section 15 of such. Now, I can agree, my lord. Some of the writ petition on 16, 2 persons appear, not the petitioner. Number 2, my lord, I can agree also 6 of them, 7 of them, I'm sorry, 7 of them.
See, if it is a king, how do you know they are not representing you?
But therefore, my lord, they say that the hearing was done.
See,
I want to show.
Nokma of such and such a king, so and so appeared. So Nokma appears, it is construed because no individual notice was given to you. A king notice was given to
Nokma and few individual appear. But there was no hearing. What I'm trying to say that there was no hearing at all. Hello.
No, but then this basically takes away your contention. Basically, if it is shown that then 15, then there is a hearing also 15.
Therefore, my lord, if there is a hearing,
see, it says report on here.
The report, where is the hearing? Therefore, I'm going to point out, my lord. It is a report. Report is based on the hearing. But where is the hearing? Showing attendance of the landowners.
See, hearing cannot be reflected here. Hearing will be there in the records.
The collector would have annexed it. Even they can produce before, my lord.
Record can be
if
very
required.
bulky.
If required.
See, who said what has been considered, what has not been considered. You see?
So it must be with the collector if he has done it.
It's a summation of all those things.
Well, that's true. So, what is the report here, man? It has nothing to do with the complaint raised by the petitioner. Since no one appeared.
No, but then in such a case, it is not the case that there was no hearing at all.
No hearing.
Rightly or wrongly, there appears to be some hearing. Then against page 222 also you will say report on hearing.
Page 22 is the Aking where most of the writ petitioner came from this area. I must fairly point out some of them may appear on that day. Now this one, serial number 6, page 222.
Yes.
Serial number 6, serial number 19, 16, serial number 16, 19. 3 of them. It claims that they appear. Now there was no hearing. If there is a hearing, where is the recording of their objections by the collector? And other one, page number 223, another Aking. 7 people appear, none of the petitioners are there.
This report only says about who appeared, nothing else.
Nothing.
So it is kind of attendance sheet.
It seems it is attendance.
There is no report.
No report at all. No content of the hearing also.
Yes. So it appears from this thing up to 228, whatever it is, there is no report. It is only a list of person who appeared, nothing.
Who appeared.
Where is the report? There is no report. Yes.
Well, with profound respect, may I request once again page number 264. Letter issued by the collector. After
Yes.
preliminary notification. My lord, collector sought this clarification from the district council. That is also one. So he himself doesn't know, my lord. And the district council letter, page number impugned order,
It is,
page,
yes.
page number 220, 66. Impugned order of the district council.
No, district council. This is a communication.
It's a communication, my lord. Now, communication here, the district council has.
That is between them only. The manner in which they assess the rate and all. That is their internal thing. Which way you can do. Whether whether this report should be given credence to or not, that is collector's business, not your business.
My lord, he has given credence, and the report is against it first to me.
That is all right. That is okay. You can challenge the report.
But therefore, I challenge
you can say that this cannot be basis of report.
My lord.
But then that is
Therefore,
there
I challenge
is no requirement of quashing this.
Therefore, I challenge that it is a violation of the principle of natural justice. The district council will give a report to the collector, taking away my rights.
See, so far as the assessment of rate is concerned, which way they assess, I don't think that you are required to take part until unless that situation comes when you are given notice before preparation of the award, isn't it?
Right, isn't.
So, some more are there. Still there.
My lord, it is. My lord, I would close my argument. I'll close my argument. My lord, those are pages, my lord. I will not drop my lord. I will not drop my lord. And only the few annexures may I point out to the counter affidavit of the collector. And immediately, district council did not file any affidavit. Though I challenged their action, their letter. District council did not file any affidavit. They are not even contesting.
Not required.
Contesting.
District council, it is the collector who is answerable for the conduct of the proceeding. That the collector answer.
My lord, I will only show on only one annexures of counter affidavit. I'll my lord, stop my argument. Subject to short rejoinder after my friend give the email.
You will now take us to the affidavit of opposition, then to your rejoinder.
No need to go for rejoinder.
No, it's all right. It's all right. See, take us wherever it is needed. Take us.
Well, page number 310 of the counter affidavit. In the counter affidavit.
Now, if you you see like here,
collector affidavit.
Your argument basically is directed in you see like it's a multi-paged argument, you can say. Has several directions.
The multiple order
jotted down in
order
one
has
line.
been
Jotted down in one line, just bullet points, then becomes easy to address. Anyway.
But 310 annexure 7.
310.
Yes. This is the attendance sheets we have, madam.
Yes.
310.
We are yet to. Yes.
My lord. Members present of hearing in connection with the claims and objections of for acquisition of the land for widening matter. So here they try to, I've seen the averment made by the collector. Here he wants to demonstrate that he has complied with section 11, section 50. And no reports, no recording of the objections. He is unable to show that all the petitions I paid before him. Well, this continued, my lord. I would
now who have appeared before and who have not appeared before.
Yes. Now I've
out
shown
of the remaining this 46 writ petitions.
Yes. I've shown 3 of them. 3 of them. Their signatures, I believe.
3 of them they have appeared.
They appear, but there was no hearing.
None have appeared.
None appear. On that day appear, 3 of them appear, no hearing.
But the rest are all part of those acting, isn't it?
Oh yes. Right. So no hearing at all. They recorded the attendance and the matter concluded. and perhaps he prepared this one. And now he wants to substantiate that he has complied with the substantive provision of Section 50. So with that, my lord, my humble submission is that the collector absolutely failed to adhere the substantial provision of Section 50. And because of that, my lord, the declaration of Section 19 is not at all sustainable.
Who are the petitioner who appeared for hearing?
Hearing, my lord, I'm sure my
3 persons appeared, isn't it?
3%.
Read petition number?
My lord, I'll just my lord, subject lordship convenient may just identify when my friend is.
Yes, just
arguing the
pass it
matter.
to us. Just solid. You find it out. Give it later also.
My
Is that over or?
my come subject to my lord, what my friends are going to say.
Please, your lordship.
Yes, just a minute. Handling file takes time, more time. How much time will take, Dr. Mojiga? Nice. Yes. Yes,
my lord. The sum and substance of my learned senior's argument.
you are appearing
For the collector, my lord.
for the collector only.
For the
Respondent
collector.
numbers?
1 to 13 for the state and the collector.
Okay. Yes.
And so the sum and substance of my learned senior's argument, as I understand, centers around procedural impropriety, particularly Section 15. What had happened in and around the hearing around Section 15, and their claim is that they were not issued notices and they were not heard on the Section 15 objections. Now, for some reason, they have gone through the law on the subject, except taking your lordships to the Section 15 objection and the Section 11 notification. I must point out, Lords, there is no Section 11 notification enclosed to the writ petition. It is impugned, it is challenged, but it is not enclosed. Kindly see page 187
Of the writ petition.
of their writ petition.
Yes.
So lordships will see at page 187.
Yes.
Lordships have that, page 187. I apologize, not page 187, page 133. I apologize, 133.
You want?
133.
133, not
133.
187.
No, I'll just come to that a little later. 133
Yes.
is the typed copy of a Section 11 notification. The actual notification has not been enclosed or brought on record. So the date assigned here is 27/6/2019.
Yes.
This is the date of the notification. Kindly see the next page. This is a forwarding letter dated 24th June 2019 from the DC
Yes.
to the Joint Secretary, forwarding the draft preliminary notification. And if your lordships turn further, your lordships will find the draft preliminary notification. This does not have any date. This was what was sent to the Joint
No, this
Secretary
is-
for publication.
Next letter is 24 June.
Hello?
The letter
24 June is a forwarding letter. Forwarding letter. But the actual notification is not on record. They have impugned it, but did not bring that on record.
Then if it is
So what they've brought is a typed copy. The actual copy is not on record.
then what is the problem with it? If it is
So the fact remains, most consistently we've seen in the courts, unless and until the document has been enclosed, the writ petitions are not entertained. What are they seeking to challenge?
It's a public document.
Perhaps not. But what I'm saying
There
is
always,
the
always-
actual document is not on record.
Are you saying that it is
No,
not?
no, I'm not saying that. But as a matter of form, this is a challenge. They've gone into the question of propriety. So I'm also just taking the same ground that the Section 11 notification is actually not enclosed with the writ petition. That is one point. Lordships will consider that. Then kindly see.
Come to a more powerful point.
Yes, yes. The most powerful point, Lordships, is the objection at page 187.
You want us to record it and then that this is not this thing. See,
I'll leave it. Lordships have expressed their mind,
you are
then I
not
won't,
disputing.
then I
it.
won't
If you
pursue that
dispute
point.
it, then also.
Then I won't pursue that point. Lordship.
Yes.
Lordships will see this is the objection that was filed, and may I just take your Lordships to section 15 to see what section 15 actually envisages. Section 15 of the Act, and I'll then take your Lordships to the actual content of the notification, of the objection. So far, the petitioners have not taken Lordships through the contents of the section 15 objection.
Yes. Hearing of objection.
Yes. Hearing of objection. Any person interested in any land which has been notified under subsection 1 of section 11 as being required or likely to be required for a public purpose may within 60 days from the date of the publication of the preliminary notification object to only these three issues. Number one is the area and suitability of the land proposed to be acquired. So therefore, it could be that one says that I am acquiring this property for setting up a school or whatever it may be. The persons who are interested may say this is not suitable. This area is not suitable. We would like you to shift to another area. So that is the
cannot raise any grievance with regard to measurement of the land.
Yes, my lord, precisely. So otherwise they would have used the word measurement. They have not used it. And kindly see what they've said: the area and suitability, not area or suitability. Then kindly see the next one: justification offered for the public purpose. So if one says I'm setting up an industry for a corporation, they can legitimately come and say this is not really a public purpose. You're doing it to help somebody out, a corporation out. The third is the findings of the social impact assessment report. So these are the only through specific grounds on which they can raise an objection under section 15. Now kindly see their objection at page 187.
Yes.
So this reads, dated 5th September 2019, objection and complaint by the project affected people, Begongre, Aking sector, on the land acquisition process by Government of Meghalaya, so and so. So only those people from Megongre have filed the objection. The other three Akings that my learned senior was referring to, they did not file any objection. Please take note of this one, because this is crucial. Who has filed the objection under section 15 can only come and contest that they were heard or not heard. So only some people from the Megongre Aking apparently filed this objection. On land acquisition process by the Government of Meghalaya, notified by it dated 27/6/2019 is the date of the section 11 notification, and apparently published on 11th July 2019 in Shillong Times and 11th July 2019 in Salantini Janera. It then goes on to read, we the project affected people residing along both sides of the NH51 Megongre Aking sector would like to bring to your kind notice about your objections and complaint against the process of land acquisition and conduct adopted by the NH JICA authority as follows. That the design change has appeared in the aforesaid newspaper, that is from so and so to so and so, in the case of Megongre Aking, has mentioned in the numeric about the length of the land holdings only, whereas the width in most of the cases have been shown to be so and so, 0. That it may be observed that the chainage from so and so to so and so on both sides of NH51 either belong to private party or the Nokma clan lands. This is intrinsically connected to the ROW. That it is a routine process that the private lands, depending on the incumbent's application before the GHADC, the land plot were then measured by the GHADC authorities authorized representatives, and the assessment were accounted from the edge of the existing NH51 and then issue the necessary pattas to the concerned incumbents. Accordingly, the GHATC has been collecting the required stipulated annual premium and landholding taxes from the representative patta holders. As such, all patta holders are the rightful owners over the respective private pattas lands. That the GHATC being the esteemed temple of the Garo tribes, and if or really plan or wish to expand and develop any part of those roadside land for the public development purpose in future, they GHATC should have never included that numeric stretch of land measuring 35 feet 10.67 meter into the individual patta. Rather, the assessed required lengths and areas, that is so and so, should have been curtailed from the patta land or holders. That it may be observed that in para 4 of the patta issued by the GHATC to the landholders has mentioned that the stretch of 35 feet meter of land should be surrendered for the cause of development in the public interest, but whereas nothing sort of notification nor land acquisition act were never followed and conducted to acquire such land plot area or areas by the GHATC. That in spite of all those commission committed by the GHATC in the matter of land acquisition earlier, it is also observed
Is it
that
required, Mr. Shen, to go through the entire thing?
I'm just trying to indicate, my lords, that
None of
no
the-
issue with regard to A, B, and C appearing in section 15.1
Right, come to the
was
next, come to paragraph 7, read the paragraph 7.
Lordship.
There is
In
no
light, yes, in light of the above stated facts and circumstances, we the domiciles firmly request your honor to kindly look into our genuine grievances and arrange a fair and reasonable compensation. So there is no objection under section 15. So my learned senior friend has gone to the law, but the facts are not supporting his case.
Yes.
That ends the case there, my lord. That completely ends the case.
Yes.
If there is no section 15 objection, where is the case for hearing section 15?
So this is basically is not an objection.
Lordship,
Rather,
it's not.
you see, like a signal to go ahead, green signal to go ahead.
Yes.
Ensure you pay us fair compensation.
Yes, and in fact, if your lordships look at the first paragraph in the same page, 188, what they're asking for is 100% compensation, 12% interest for 18 months. These are statutory benefits that they'll be entitled to as we proceed. So therefore, my lords, I'm saying there is a reason why at the very earliest opportunity, the learned single judge did not interfere in the proceedings.
Yes.
So attempt has been made, a lot of time has been spent to establish the law. We don't dispute it.
Come any other point, yes.
We don't, that's the point, my lords. If they're restricting themselves to this, matter ends here. And also kindly see, towards the end, my learned senior digressed into another point. That in the before the section 11 notification could be published, there was a meeting, and in the minutes of the meeting, the DC held that they would exclude ROW. He's gone into that as well, and therefore he says the court should interfere in that. Those are minutes of the meeting between them and some of the Nokmas. Now the question is, if for any reason certain areas have been excluded from the section 11 notification, would your lordships interfere in the section 11 notification then? It is their wish. At best now they'll file a civil suit to assert title over that 35 feet. Nothing beyond that. How can the LA proceedings be interfered with?
Definitely, that should not.
Governments internally have decided that some areas are not to be acquired.
No, even the referee court can do. They can
Lordship.
always say
Yes.
that see the compensation has been granted. It is not a this thing fair compensation.
Yes.
In view of the fact that we are not paid for ROW.
Yes.
Then that court will take a call whether
Yes.
they are.
So if something is excluded, they can raise it under 64. They can raise it and say that look, some of the area has been excluded. You've not paid me, but you've acquired it.
Area is 64, isn't it?
Area, yes, my lord. Measurement.
Measurement.
So, my lords, what I was saying that section 15, the expression area has to be read in a different context. So, if your lordship sees section 64,
You see, there is the page 188 makes it clear.
Yes.
They have not objected.
there is no objection.
So why do we go and interpret that area word in all this? They have never raised any objection. They have never said that you have objection.
My lord.
Isn't it?
Yes, yes. So 600 pages are before your lordships, but what is most relevant are these 2 pages.
What is the provision, that earlier provision of section 80 and section 30 in the new act?
My lord. 18 is 64.
Okay. And then other one?
5A. 15 is 5A.
No, 30, section 30 is?
That is 76. Dispute as to apportionment 76 and the reference is 64.
Yes, anything more you want to say?
If lordships have any question, my lord, because my learned senior was confining and stressing only on this issue of section 15, that they were not heard, their objections on record, notice was not served, and they've established several case laws. I understand that, but then the fact remains that there is no objection under section 15, and especially from any of the other akings. This is only with regard to certain people from.
If there is nothing to show on the record,
Lordship,
that the other aking had filed any objection, then it will be construed because
they waived their
stipulation of
rights.
Time is 60 days, isn't it?
Yes, my lord.
So once
60 days from the date of
expires,
publication.
it will be implied that there is no.
Yes,
isn't
yes. And in addition, kindly also see, this is what we are trying to conduct this exercise because we are not very clear with a lot of names. This particular objection was signed apparently by 66 people. Several of them are not even parties to this writ petition. So presently, from what we have figured, it's roughly about 18 people who are signatories who are also writ petitioners. So the others cannot seek any benefit from this. Even if lordships were to.
So these 66, all these 66 signatories are not writ petitioners.
No, they're not writ petitioners. And after having culled out those who have already accepted the compensation and have been struck off, from what we understand, there are roughly about 18 people who are signatories here and are writ petitioners.
Out of remaining 46,
Lordship.
there are 18 people are signatories.
Yes.
Anyway, but then if that section, see paragraph 7.
Yes, madam.
The last part of this thing, you see, like it doesn't say so. It is a kind of, probably you see, like it has nothing to do with the objection.
Yes, it's no objection, and the objections have to be centered around section 15(1).
Yes. Anything you want to more you want to say?
No, sir. In case my learned
So your
senior is
case will
something
be that there was no objection.
there was no objection filed. So they had waived any right.
The application which the petitioners are trying to term as an objection under section 53.
Yes, sir.
Is
It's
not
just a
at all.
representation asking them to follow the due process. So there is no foundation for the case.
Yes.
I'll just reserve some time in case my learned senior wants to add something.
You still want to give some more opportunity to senior?
I'm sure my
Normally,
learned senior
petitioner concludes.
will want to
the hearing.
contest this.
Yeah, the respondents want to conclude the hearing. I have the right to rejoin the respondent has no right to rejoin the implied
Definitely,
party.
but then we will hear Dr. Mojika.
Other
before
side
we
is
come.
there.
So you can reply together.
Yes, yes.
But then don't take another day.
Yes.
Then my friend. So rejoinders should be shorter than the reply. Now, yes, Dr. Mojika, what you will say? Though you have removed.
But I have a very limited role, my lord.
Yes.
And in fact, I was also about to stress on the provision of section 15.
You are applying for a sworn number?
15 and 16. 15 and 16.
And who is for district council? Yes. You have anything to say, district council? Okay.
IP for 70, my lord.
You are who?
I am the one who conducted the social impact assessment.
So you are. What role you have to play here then?
I
Why you
only prepared the social impact assessment.
why you are made a party then?
If there was any challenge, well, of course, they made some challenge to the way it was conducted. But if they were to make any challenge, they should have filed a specific complaint under section 15. They have not done that.
Exactly. That is what Mr. Shan also has submitted.
That is covered that. Why have no argument? My name will be recorded. I'm present. My lord.
Yes. Yes.
My lord, I totally endorse what submitted on behalf of. My lord, as Lordship pointed out, that objection, what they are trying to project as an objection under section 15, my lord, that is nothing, it's simply a representation.
Simply a representation asking this thing to go ahead.
Go ahead. Allowing to go ahead,
Yes.
but give us full compensation, give us interest, give us 100% compensation, and give us compensation for right of way. And there is a different forum for deciding that, and for this purpose, my lord, the entire case projected that there was a violation of section 15, and so when the foundation is illegal, my lord, the entire superstructure has to fall. In my humble submission, there is no substance in.
So you are more or less, your contention is same, that there is no objection under section 15. So in absence of any objection, you say like this petition doesn't deserve to be considered.
That's one aspect, my lord. Second aspect, my lord, there is so much of hodgepodge. Who filed the representation, my lord? Belong to which king? Who are the writ petitioners? Who received compensation? There is no clarity.
Anyway, we may not have to go into all those things.
My lord, it may not be necessary to go into that.
Yes, Mr. Shangrishan. Now again.
My lord.
How long will take?
My lord, just 5 minutes will come. Lordship, kindly see section 15, which my friend has read out. My lord, objection to the area. Lordship, kindly see.
Why are you taking us to section 15? You just make us understand paragraph 7 of your representation.
I'll come to that.
That is what needed to be clear.
Now
we are not even on section 15 and Mr.
I'll do that.
Not going into
my humble submission with regard to section 15, with regard to area, that includes whatever the grievances of the landowner with regard to the suitability or the area measurement, whatever, they can address. Here, the grievance here of the petitioner is that the large chunk of the petitioner's land was not at all mentioned in the section 11. Therefore, they raised that objection in the complaint. Take into account.
There is no objection.
No, but I'll come.
Doesn't see any objection.
I'll come to that point.
You show us a single line where it has been objected.
Well, I'll come. Therefore, first I'm emphasizing the meaning of the area, and suitability of the land proposed to be acquired. That is, my lord, vast enough. The scope is vast enough to include that the ROW, non-ROW grievance of the petitioner can be raised.
Okay, so then that is why you are.
But the public purpose is under subsection P. Whether it is good for the public purpose or not, that is another subject matter. Another objection with regard to finding out the social impact assessment is another. But my grievance is confined to the area and suitability. I could have raised that my land is going to take away. I will be affected. My right is affected. This is my right. So to that extent, collector has to hear me. He has no power to reject. Therefore, no apex court say that
the hearing comes when there is an objection under section.
My lord, in my objection, Lordship, page 118. When we read 187, my objection, when we read it as a whole, it is indeed an objection, saying that my land is taken away. ROW is, my lord, taken away.
But then this, see, we do not know why should we give some different interpretation when your para 7 is very clear.
No,
anyway,
we'll take that thing. It should be read as a whole. My lord, these are the villagers who wrote their objections. Even I would place a decision if Lordship give me merely finding a representation before the Chief Minister amounts to an objection. Therefore, my lord, the form doesn't matter. The grievance of the petitioner, the landowner, is important. Now, in substance, my lord, when we read it as a whole, not the ending part is correct, that if we proceed in accordance with law, give me the appropriate compensations. They are not supposed to go and hijack the acquisition process. So my complaint, my lord, when we read it as a whole, it is indeed a complaint. It is indeed an objection, the expression of grievances. And lastly, my lord, the law of the pleading is important. My friend, two of my friends say that it is not an objection. my learned friend GA and the learned senior counsel said, this Annexure 17 is not an objection. There is no averment in the counter that yes, I have received this one, there is no objection. Therefore, the pleading made by my friend, two of my friends, is beyond the pleadings. Beyond the pleadings. Okay, that's it. We have to go by the pleadings. They did not deny. There is no objection. And they did not deny this one. Deny this one. And my lord, I will not go to other aspect of the matter. So this is the, and with regard to, may just clarify, my friend has pointed out that objection, how many of them has filed. I could notice with this objection itself, 26 of them, their names, the presented petitioners are here. Most of them has excluded, struck off. So 26 of them are there, not 18. Not 18. So my humble submission is, my lord may kindly interfere with the prayer material.
Yes, getting concluded, judgment reserved. You just write all the numbers of the things. See all the things who represents in the district council, Mr. Gautam. Yes.
Does lordship require brief bullet points or?
If you like to submit it, that will be open for you. But then you will have to do it fast then. Such a case. How long will it take to give bullet points?
Well, within 2-3 days, I can submit a bullet points.
That will remain open to you.
Along with
There is no problem. He
along
can
with the
submit
citation,
bullet
we can serve copy if they can.
But then do not give submit in lengthy argument. Only the.
It is confined to that issue
Yes.
only, with the supporting judgments only. In the meantime, lordship may continue the interim order till lordship will pass the.
See, this
final
is
order.
this will be. This is in the last. What is the last order says?
But interim order continue.
Until further orders. So if until further orders, then it's already there.
Yes.
It is already there. And if it is until further, then it's until further.
Why not? Well, I'll verify whether it is until further or till today or not. I'll just look at it.
The order dated 12/9. In the meanwhile, interim order dated 2/9/24, passing down this one to shall continue
Until further.
Until further.
Until further. Then it's there. Do not do anything before judgment is passed. No, Jika.
We will not pay compensation.
Yes.
Keep the order.
Item number 4.
Yes.
Your Lordship, 2 weeks may be allowed
You are applying for the petition.
for the petitioner, Your Lordship.
What is this matter about? That is
Conviction.
This is Assam Rifles Court.
this was heard by other court at some certain point of time. There appears to be some noting by other court.
Because his departmental appeal is pending before the authorities, my lord. In the meantime, he has come. It was stuck on that level, my lord.
Oh, sure. Okay. If departmental appeal is pending, then what is the scope for us to interfere?
My lord, exactly that was the question. They disputed that the departmental appeal is not pending, and they filed some RTI, but it appears that the departmental appeal is still pending, and we have not been able to dispose
No
of because of,
information whether appeal is pending or not pending. Departmental appeal. Any instruction you have? You do not have.
No, we didn't receive any
So we'll
instruction.
adjourn it. As requested by yes, by the petitioner. This is after 2 weeks.
Much obliged.
Item number 7.
Yes, Mr. Shaikh, I intend to argue right now.
Lordship petitioner is not here. So Mr. Kharmi is the counsel for the state lordship. So yeah.
Petitioner is not there.
Yes.
What is the matter about?
This is a quashing lordship. Criminal petition lordship.
None appears for the petitioner. Mr. Shaikh, Learned GA is present and we have the respondent.
1 to 4.
You are preparing for all the respondents?
1 to 4 lordship. There is a private respondent.
Yes, this matter after 3 weeks.
3 weeks, Lord.
After 3 weeks. Yes.
Item number 8.
Here also regarding that matter, lordship, that criminal appeal that Mr. Upadhyay has filed as a legal counsel. Subsequently, another appeal was filed by private counsel, then subsequently it was withdrawn, Lordship. Now, on the previous occasion that Mr. Upadhyay has withdrawn as a counsel.
Nobody appears, then
Yes,
again court
Lordship.
will have to appoint somebody.
Yes, Lordship.
Criminal appeal cannot be
Cannot be.
dismissed.
Yes, true, Lordship.
This is a difficulty.
Matter was hard, in fact.
This is a real difficulty. And now Mr. Upadhyay has already withdrawn.
Lordship,
We cannot again make a request to him to come back.
Lordship, what I pray, at least one more chance may be given, so that in the meantime, if they are not appointing.
Mr. Sheikh, we are not in a position to dismiss, so we have to give them chance. We are compelled to give.
Yes, then after that the court can appoint.
If court has the opportunity to dismiss, the court will do it very fast.
Criminal.
Yes, none appears for the appellant. Mr. SSI appears for the respondent. Paragraph, it appears from the no, you just say, you say by order dated 2024 SD for the London Legal Aid Council appearing for the appellant had withdrawn himself from the case on the ground that the appellant was desirous to appoint a counsel of his choice. Stop. However, none appeared for the appellant. However, just say, however, there is no representation for the appellant. Give a paragraph. Say, this is matter for 2 weeks or 3 weeks. Make it 3 weeks. To enable the appearance of counsel, appearance of counsel of appellants choice. What is it? Read this matter after 2 weeks. To engage a counsel of his own choice. Yes. Or make it to avoid the appearance of, you say, to avoid the appearance of counsel of appellants own choice. Yes.
Item number 10.
Yes, Mr. Smith. I don't know. This. Yes, Mr. Das is also there. What is to be done?
This matter I can propose. The complainant is here, it will person here, but you can settle the matter with some monetary. Because this is simply what happened here, my lord, because of blood, my lord.
Why monetary thing comes? It's a question of criminal petition. If they have to do it, let them do it amicably. You do not have to.
That was what I was submitting, my lord.
That is outside. That is what you do outside is not local. But then this court will not cognizance of what you say if you about the settlement with regard to money.
I'm proposing there here.
Perhaps your lordship remembers this.
Is it what Mr. Das desired just now?
They
No,
can
no, no, absolutely
no,
not, my
they
lordship.
can approach the civil court if they are in the.
Yes, yes, my lord.
This is regarding the matter where the collapse of the boundary walls due to natural calamities. Whether I've been allowed to continue even after the filing of the FIR. I produced a certificate, and that was heard at length, in the lordship. That certificate needs to be produced, which I have the certificate that I was allowed to continue by the CPW even after filing of the FIR under their supervision. There's no malifying intention on our part to for the collapse of the wall. It is because due to the natural calamity, because of the heavy rainfall, incessant rainfall. That has already been there in the report by the IIT department. That is there. There is no malify there. And if the decimal number 7 is agreed, there are other ways to approach. They can alternative remedies there for their compensation. whether criminal, and in this case, my lord, the final report has already been submitted. Earlier, my lord, there was some other accused, and here, my lord, even without going through the merits of the case, but even in the charge sheet, they have stated in the charge sheet that the work has been under the supervision of the department, concerned department. I mean, the contractor. I've been made a scapegoat now. The concerned engineers, the concerned FC authorities, they have not been implemented.
There appears to be no
Provision
criminal-
of 319 is there. If others are involved in this particular case, my lord, then my lord 319 will come for the HCRPC. But before
19 comes at a different stage.
my
isn't
lordship,
it? It's
but
at
I
the
am
stage of
trying
evidence.
to, what I am trying to, my lord, at this my lord point of time, what my submission would be, my lord, only this honorable court would see that whether a prima facie case is disclosed.
That's what I'm trying to say.
I'm not on, my lord, whether a prima facie case is made out or not made out from the FIR, whether it discloses a prima facie case.
Exactly, that is what the law is.
My lordship. And apparently, my lord, once the charge sheet is submitted, definitely, my lord, it indicates that there was a prima facie case in the FIR. And why I am submitting, my lord? Because this incident started not in the year 2020, not in the year 2022 or 2024, my lord. It started way back in the year 2012. It is on record, my lord. During, my lord, if my lordship may take up this matter on any other date, I'll.
You agree on a date, then we can just try to finish it.
After puja vacation, my lord,
no,
any date, my
here,
lord.
what happened, the charges has been submitted.
See, Mr. Smith, there is no possibility of taking up this matter today.
No, that I agree, my lord. Not today, my lord. But I am praying for a short date because what happens, my lord, charges has been submitted, GRK has been raised. It is me who has been suffering, and I have been asked to appear before the court. And if your lordship may stay the proceedings, my lord, that I have no objection. It may come after puja also. They have no
Staying
objection.
of proceeding also has to be on the basis of prima facie finding.
My lord.
So some order is needed.
My lord.
That
And
what
there
the
is
big
no-
thing is that why should we do it? Is that at the end of things?
That's my lord. And let it come after a week, my lord. Everything, my lord, the parties are here, my lord.
After puja vacation, my lord, any date, my
My
lord.
lord, no, I have objection after puja vacation because, my lord,
Because,
it's a
my
long
lord-
date. I have to appear before the court, my lord. The matter is fixed on 28th.
They have not challenged the FIR charge sheet, my lord.
No, but there is no bar,
But
my lord.
in spite of that, the Honorable Apex Court has said that yes,
There is no bar.
FIR can be quashed, my lord. So I am not into that, my lord.
See, Mr. Smith, if we keep it next week also, it will be very difficult.
Well, after 2 weeks, my lord.
See, this is the problem is that this court has to sit in division benches. There are
My lord,
two
that
division
I.
benches in a day.
Yes, my lord.
And last week would be motion week, my lord.
Well,
And if you come and sit here the whole day, then
My
the
lordship.
purpose is served.
Well, that-
And last week would be motion week, my lord.
Well, at least we can give it a try, my lord. That's what I'm saying. Because I am the one who's been suffering, my lord. I am the one who's been made a scapegoat. Well, I had 2 weeks, my lord. If not a week, my lord, 2 weeks, my lord. In the meantime, my lord, I'll also have to.
Let us keep it after 2 weeks, then Mr. Das. I do
My
not
lord,
know, but
the
2 weeks will
puja
be-
vacations are there, my lord, after 2 weeks. Last week would be, my lord, the motion week, my lord. That is why I am making this submission, my lord, that
2 weeks also,
after puja vacation, my
Mr.
lord.
Smith, it will end up in holiday time.
23rd, my lord, a fixed date, my lord.
Of
October, immediately on reopening, my lord.
My lord, after reopening, my lord.
opening was there. Here we have you see, even
Well, let it come after 2 weeks, my lord. If there's some difficulty or it isn't, then we can accommodate.
Because after submission of charge sheet, they have not filed for any, I also for stay of the proceeding, my lord. That is
that will
left
do.
on
That's
their
why, my
part.
lord, because it was only an pagan
we are
of the
having
money hearing.
difficulty in fixing a date also.
My lordship, I understand. After puja vacation, any
Well,
date, my lord.
I'm objection to the after puja vacation, my lord. Let it come before the vacation, my lord. After 2 weeks, my
Puja
lord.
vacation only. Yes, that is what
No,
I'm
let it come after 2
trying to
weeks.
point out.
Okay, then, Mr. Das, let us have it after 2 weeks. We'll see. If you have a difficulty, then we'll just see.
My lordship, my lordship. Deeply obliged.
If date
After 2 weeks, no date. Can I go, sir?
Yes, requested with you.
After 2 weeks, any date will come after vacation. That is why on 23rd you fix it.
Dr. Mojik, I will have no problem. You will be here after 2 weeks.
23rd you take.
My lord, then if the puja vacation starts from 5th, my lord, then 13th, my lord.
This exactly
15,
what
my
this
lord.
court is
My-
trying
sorry,
to
my
point
lord.
out. See, you
I'm-
know what happens before festival, after.
My lord.
Yes, my lord.
My lord, 17, my lord.
23rd, my lord. Matter of 2-3 days, my lord. Saturday, Sunday is closed.
But 23rd, Malad, that it will be better, Malad.
Okay.
23rd.
Yes, just say as agreed with the parties. This matter on 23rd. 23rd October.
Deeply obliged, highly obliged.
No, there is no problem for you. Mr. Shaikh also will be here.
Nobody has problem. Only me. It's me who has been in the.
No, the problem is with outstation lawyers.
My lordship. Highly obliged. Highly obliged.
No,